now we are really in that wrap-up mode of, putting everything together in the mind. So if you could help us do that and formulate what you have to
It's
say,
all
that'll-
set out in the note that I have given.
Excellent. Okay.
So, Mulaz, we don't have
So
to
we can
really
get
travel
the note
anywhere else.
Just formulate it.
That's right. Mulaz, I just wanted to mention one other broad point, Mulaz, before your Lordships will allow me to respond to your Lordship's query a little later, if your Lordships permit me to do that. I just wanted to make one other broad point, Mulaz. And that is, if your my lords look at Article 180, sub-article 1. Sub-article 2. 1 or 2, Mulaz, both may be read together. Your Lordship has that. While the office of a speaker is vacant, the duties of the office shall be performed by the deputy speaker, or if the office of the deputy speaker is also vacant, by such member of the assembly as the governor may appoint for the purpose. The governor may appoint for the purpose would be on the advice of the council of ministers. And during the absence of the speaker from any sitting of the assembly and deputy speaker, or if he is also absent, such person as may be determined by the rules of the procedure of the assembly.
So
or
one
if no
deals
such
with vacancy, second deals with absence.
So, Malaj, either way, Malaj, if both of them are absent or for some reason cannot participate, somebody else will be appointed.
Right.
Right? Now, in this context, look at paragraph 6.2 of the 10th schedule. They have to be read together. Just another broad point I wanted to make before your lordships. The proviso to 6.1, Malaj. I'll read 6.1. If any question arises as to whether a member of a house has become subject to disqualification under the schedule, the question shall be referred for the decision of the chairman, or as the case may be, the speaker of such house, and his decision shall be final, provided that where the question which has arisen is as to whether the chairman or the speaker of a house has become subject to disqualification, the question shall be referred for the decision of such member of the house, as the house may elect in this behalf, and his decision shall be final. So what is it that I am canvassing before your lordships? That there can be no hiatus.
Right.
If there's a deputy speaker against you who have given notice, the disqualification proceedings don't stop. That's my first one. Is at the outset, I made that submission to your lordship. They've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, Malaj, is as well as the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided over the house and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the house is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No, but the person elected as the speaker then, or chairing the house, will decide. There is no committee.
Read with 180.
Yes. There is no committee. So therefore, all this not dealt with in Nabam Rebia.
What's the ground for removal of this?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing.
So that was not a disqualification. He was not being removed under
disqualification
under the 10th schedule.
Correct. Therefore, that notice was an ab initio void.
No, but they can always say that, look, we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed your lordship Shakhtar and call, which says it has to be for reason. I showed that to your lordships at the outset. Because removal is stigma, which is why Malaj is allowed to be in the house, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in NABAM. So these are very serious questions. That's another broad point I wanted to make, Malaj, before I proceed.
Yes.
Anyway, now kindly come to the propositions that I have placed before your lordships. Malaj, it's already with your lordships, I hope. My submissions, the rejoinder submissions, Malaj. Document number. It's not numbered.
A what?
In rejoinder on 14th of March.
That is A4 is Mr. Sibbles, is it?
Yeah.
Petitioner rejoinder written
Got
submissions.
it.
Yes, that's correct. So, Malaj, all that I've set out now so that I don't have to, Malaj, wherever necessary, I'll refer to the document, otherwise not, Malaj, because your lordships have actually gone through all the documents. But, Malaj, first I will deal with item number, Malaj, page 2, 3, and 4, Malaj, the submissions made by the other side, which I'm going to deal with presently. At page 2, Roman small 3 and Roman small 4.
Petitioner respondent.
Their argument was, Malaj, as your lordships will notice.
Page 2.
Yes, Malaj, 3 is the respondents have not incurred disqualification under the 10th schedule because their claim is not that there is a split, but that they represent the Shiv Sena. That's their case, which has been decided by the Election Commission in their favor, that there is no distinction between the legislative party and the political party, and the 10th schedule does not stifle the right of the legislatures to dissent. That's their argument. I hope I have encapsulated, Malaj, accurately. Then next 4, respondents have not incurred disqualification under 2(1)(b) of the 10th schedule because the respondents had appointed their own whip, Shri Bharat Gogavle, on the 21st of June, and they have obeyed the whip issued by Gogavle. The legislature party has the right to appoint the whip, relying on members of Maharashtra Legislative Assembly disqualification on grounds of defection rules. I hope, Malaj, that's a correct articulation of what they've said. Now, Malaj, our answer, kindly straight away we'll come to the heading, Malaj. I first deal with the governor.
Why don't we deal seriatim with your submissions actually? Governor, from A onwards.
All right.
That
I
might
can
be
do that.
better
I
so
thought
that
I
you
would finish the governor first and then.
Yeah, exactly. That is A at page 3.
Three.
Capital A.
Capital A, yes. A,
Governor's decision.
that's correct. Give me a minute. Yes. It's capital A. Non-recognition of factions under the Constitution. That's the one, Manoj?
Governor's decision.
No.
Page 3, page 3.
Page 3A.
Page
Capital.
3 bottom, top.
Para 5.
Para 5. Yes.
Oh, okay, yes. Yes, governor's decision. The respondents contend that it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the assembly, and further contend that by whatever process or means the governor can gather the information that was required, which raises a credible doubt as to the majority of a government in power. In support of this contention, reliance was placed on the law laid down by this Honorable Court in Bomai and in Shivraj. That's their case. It is respectfully submitted that the respondent's contention is misconceived and is based on a misreading of the law in Bomai and Shivraj. It is settled law that the governor's decision to call for a trust vote is subject to judicial review, and the same is liable to be quashed if it is based on extraneous considerations. In Shivraj Chauhan, whilst holding that the exercise of discretion by the governor to call for a floor test is subject to judicial review, this honorable court observed that, quote, the court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of power. The exercise of such power is not intended to destabilize or displace a democratically elected government, accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of the satisfaction by the governor is not based on extraneous considerations. That's the heart of the decision. It's not merely that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships. Then, Malaj, the governor cannot resort to whatever process or means to gather information which casts a doubt on the confidence enjoyed by the government in the assembly. The governor's satisfaction has to be based on relevant and constitutional considerations. In the present case, the governor, in his decision on 28th of June, arrived at his satisfaction that the government headed by Uddhav Thackeray had lost the trust of the House on the basis that, and I quote, majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislature party that they intend to exit from the Maha Vikas Aghadi government. That's the heart of the matter, Manas. That's the decision of the governor, that 34 of them have come to me, and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkaria Commission, Malas, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any three people from any party will go to say that now you must call for a floor test.
All right, let's read ahead so that we'll get your formulation.
Yes. Firstly, it is respectfully submitted that the resolution of 34 members of Shiv Sena, which is relied on by the governor in his decision on 28/6, does not state that the 34 members intend to exit from the Maha Vikas Aghadi government. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say, Amara, they want to move out of government? Only 8 of them. Thus, the governor has misread the resolution of 34 Shiv Sena MLAs as demonstrating their intention to exit from the Maha Vikas Aghadi government, and consequently his satisfaction about the lack of confidence enjoyed by the government is based on extraneous and irrelevant considerations. Secondly, para 7 of the governor's decision makes it clear that the governor based his satisfaction on a claim made by a majority of Shiv Sena MLAs against the government formed by his own political party, their own political party. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? It is respectfully submitted that the governor has no power to recognize a majority faction of a legislature party, and on that basis come to a prima facie conclusion that the government has lost the confidence of the House. By doing so, the governor enters the political thicket outside the domain of his constitutional duties and facilitates the toppling of an elected government, which is impermissible in law. Paragraph 3 of the 10th schedule, as it stood prior to its deletion, stipulated that where a member makes a claim that he and any other members of his legislative party constitute a group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party, the same would constitute a valid defense in a disqualification petition filed against such members under paragraph 2 of the 10th schedule. Malas, my lord asked me this, a question related to this. Malas, paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and gave that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. And Milad, if your lordship reads paragraph 3 with me for a minute, well, it's very interesting. Original paragraph 3. Statute compilation, PDF page 50. Where is that? Statute compilation. Yeah, yes, I got it, yes. Yes, now kindly see paragraph 3 as it was. Your lordship has, it's at page 48, PDF 50. My lords have it?
Yes.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in the original political party. Any such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 on the ground that he has voluntarily given up or that he has voted or abstained from voting. From the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of para 2 and to be his original political party for the purpose of this paragraph. So what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework. Because he is not the party. Because the party is registered, Malad, under section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And Malad, the constitution as accepted is the final document. He can't now say, I am the party, because the party with the Election Commission and the party with the speaker is only the members of the legislature belonging to that political party. So you can't say, I am the party. So that proposition is unfounded in constitutional law. So I'll read, I go back, Malad, to my submissions. So, Malad, I go back to my page 5. Thus, paragraph 3 as it stood, I'm sorry, you also have that?
Yes.
Yes.
Thus, paragraph 3 as it stood recognized a faction of the legislature party arising as a result of a split in the political party. And Malad, your lordships have now read all the documents till July the 4th. Is there any reference to any split? No reference. No mention of split. With the deletion of paragraph 3 of the 10th schedule by the Constitution 91st Amendment, there is no constitutional recognition of a faction or group in the legislature party. Reference is invited to petitioner's written submissions 160 to 163. Malad, your lordship have it. I've given the page so that it's easy, Malad. The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? Malad, there's a constitutional basis for that also. I tell you just why. Malad, when I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the House and outside the House, I continue to be a member of that party and must honor the discipline that's imposed on me. So in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party, both inside and outside the House. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip. Because there he represents. That's why Holohan says you can't go against it. That's the rationale for it, Malats, constitutional rationale for it. Then, Malats, a fortiori, therefore, the concept of a faction asserting itself in the legislative party and acting dehors the political party or calling itself the political party is not contemplated by the law, and any such claim will be per se foul of paragraph 2 of the 10th schedule. Parliamentary democracy only recognizes alliances between political parties, and not an alliance between a political party and a faction of a legislature party. That be constitutional harakiri, Malats. Reference is invited to the order for preference to be followed by the governor as stipulated. Malats, kindly have a look at that page only, Malats. Kindly come to my written submissions, page 101, Malats. Right, 101.
Which file would that be, please?
Petitioners written
Yes,
Petitioners,
101.
written submissions. Page.
Yes. Now, Malats, kindly share. Very interesting. Yes, yes. Yeah. Kindly see page 101, paragraph 240.
Yes.
Yes, it is submitted that the governor cannot recognize the rebel MLAs and of political parties, as that would ring a death knell on the working of a multi-party democracy. The Sarkaria Commission's recommendations approved by this Honorable Court in Rameshwar Prasad also categorically emphasize the importance of sanctity of the party system and states that the governor, in arriving at a satisfaction to invite a chief minister, can only recognize alliance of parties and not an alliance of a party, in this case the BJP and rebel MLAs of another party. In this regard, para 65 of Rameshwar Prasad reads as follows. Para 4.11.04 of the Sarkaria Commission report specifically deals with a situation where no single party obtains absolute majority and provides the order of preference the governor should follow in selecting a chief minister. Now, this is final. What does it say? The order of preference suggested is 1, alliance of parties that was formed prior to the election. So parties, alliance of parties. 2, largest single party staking a claim to form the government with the support of others, including independents. Again, largest single party. 3, post-electoral coalition of parties with all the partners in the coalition joining the government. And 4, a post-electoral alliance of parties with some of the parties in the alliance forming a government and remaining parties, including independents, supporting the government from outside. There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shiv Sena had gone to the BJP, governor will call for a floor test. If the Shiv Sena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, Malad, I said to your lordship the consequences of it. Malad, supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of six of these people reduces the chief minister to a minority, therefore call for a floor test. Malad, it would be disastrous for democracy. That's the Airam Gayavaram principle that we gave up. Would 50 members of BJP today, Malad, support Uddhav Thackeray, will he call for a test? So, Malad, the whole propositions, the propositions that have been advanced by my learned friends are all contrary to basic principles of constitutional law. I go back, Malad, to my submissions. So, Malad, para 20. Therefore, the recognition of a faction of a legislative party as the basis to cast a doubt on the confidence enjoyed by the government in the House would be an act of constitutional impropriety and legally mala fide. It is respectfully submitted that under the constitutional scheme, a member of a legislative assembly set up by a political party does not have any independent identity in the House. Dehors the political party on whose ticket he is elected to the House. The same is clear from the following. Now, this is important. Kindly see Article 170 of the Constitution and kindly see sub-Article 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, not less than 60 members chosen by direct election from territorial constituencies in the state. Well, I mentioned that to your lordships yesterday. Delimitation Commission, territorial constituencies, direct election from the territorial constituency. Now kindly come, let's go to item 2. Under 7.1 of the Representation of Peoples Act 1950, the total number of seats in the Legislative Assembly of each state is as shown in the second schedule. Further, Section 7.3 of the Act provides that the extent of each assembly constituency shall be as determined by the orders of the Delimitation Commission made under the provisions of the Delimitation Act. I don't have to read it, Malad. Your losses may take it that that's correct. We'll waste time otherwise. Malad. Then come to 4. The first step in the process of nomination, Section 33 of the Representation of People Act, prescribes that each candidate desirous of being elected to a seat is required to deliver to the returning officer a nomination paper completed in the prescribed form. The provision itself differentiates between candidates set up by a recognized political party and those not set up by the party. That's Section 33. No, let's not read it. That's up. Nobody can doubt what I have said. So otherwise, it'll take time. Next, the relevant rule in the conduct of election rules pertaining to Section 33 is Rule 4, that deals with nomination papers and prescribes that each nomination paper must be completed as per the appropriate form. The appropriate form for the purposes of election to the Assembly is Form 2B. Part 1 of Form 2B applies to candidates set up by the recognized political party. Further, as per paragraph 13B of the symbols order, a candidate is deemed to be set up by a political party only if the political party provides a notice in Form B to the returning officer which contains the endorsement of the political party as to the approved candidate on its behalf. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. After the election, Section 66, 67 of the Act require the returning officer, once the counting of votes have been completed, to declare the election result and to communicate the same to the Election Commission and the Secretary of the House. That's very important, Melissa. Kindly see that, 67 of the
That's okay. I think, you've paraphrased it and there's no reason to doubt it.
Right. The reason is what he sends is that he has been elected
Only-
as a- C itself says, Malad, declaration of the. Is sponsored by the political party and he has been duly elected. And the certificate also says the same thing. Would you go back to it, Malad? Then, Malad, item 9, corresponding rules of the conduct of election rules are Rule 64, 66, which prescribes 21C, Form 22 to be referred to by the returning officer. 21C deals with the format of declaration of the result of elections by the returning officer, and it explicitly requires the name of the recognized registered political party that has sponsored the candidate to be recorded. The same details are also required to be recorded in Form 22, which concerns the certificate election provided. Therefore, it is respectfully submitted that an elected member of the Legislative Assembly does not have any independent identity in the House except as a member of the political party to which he belongs. Accordingly, the governor could not have recognized any members of the legislature party, dehorsed their political party, and permitted them to make a representation against the government formed by the political party to which they belonged. So Malad, he should have assumed that they continued to be in the Shiv Sena, and that Shiv Sena had 52 members, and all the three parties together have 152 out of a house of 280. There was no occasion for him to say, have a floor test. And undisputedly, in the present case, the group of the Shiv Sena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June. On this basis, the governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. The governor is knowing fully well that a faction of the legislature party cannot be recognized under the constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So, what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left they say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the house and the strength of the number of parties in that house, or the strength of the party in that house. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget Malad, the majority. This can happen, Malad, where 2 or 3 or 4 members of each political party can do the same. What you're doing is, Malas, when there was no 10th schedule, what used to happen? The same thing. What my lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified. That's a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Maharaj, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Maharaj, your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, Maharaj, calling a trust vote has to be based also on alliances, if it's been reduced to a minority. That's accepted now by Rameshwar Prasad, Maharaj. They could have followed, Maharaj, the Madhya Pradesh model, resigned. No, but there they wanted to be chief ministers and posts, Maharaj, so naturally, Maharaj. They could have followed the other model. Maharaj, that also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, Maharaj, is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Kyoto, unless we question Kyoto.
Maharaj, I have always questioned it. I have always questioned it, but that's another issue, Maharaj.
But it also has a bearing on coalition governments,
Yes.
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party, except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray
Maharaj, in
and
fact,
setting up an alternative, because it's impossible. Virtually, we are interpreting the constitution to say that it is just not possible for any legislators.
Maharaj, in fact, this has been my grievance. What happens, Maharaj, in the United States and in the UK, Maharaj, a president, Maharaj, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, Maharaj, we are in another era.
Yeah.
At the moment, we are on the law as it stands today. So we go back to the Gyaram regime, where there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. Maharaj, there is an NCP case where only four people of the NCP, Maharaj, actually went away. There were only 4 members. All of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
Shifts.
or one member of the coalition shifts,
That's right.
that the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
Correct.
or ceased to back the government. Therefore, I feel now your vote in your confidence in the House, the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he is not concerned with the 10th schedule at all, Maharaj.
Right.
With the greatest respect.
Right.
Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership. They will come back. That arithmetic and that, the consequences are not relevant as far as the governor is concerned, or even the court is concerned. Court is to judge the act of the governor on the 28th of June, whether that was right or it was wrong. And I might say this to your lordships, when we enter this courtroom, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, this court's history has been so phenomenal, and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Mullah.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs or MPs.
That's Bomai, Mullah. Yes, exactly. Para 88 of Bomai says that.
Movement lies within the province of the Speaker under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Mullah. Intra-party disputes he can't deal with. It's in my note. I'll succumb to it.
All right, let's go back to
yes, Mullah. Sorry. So, Mullah's decision of the governor is accordingly liable to be struck down. It is respectfully submitted that the respondent's reliance on the decision of Bomai to contend that the governor is duty-bound to order a floor test without regard to the pendency of disqualification petitions is totally misplaced. The respondents particularly relied on 119 and 121 for Justice Sawant's opinion and paras 391 and 395 of Justice Jeevan Reddy's opinion, dealing with court's decision on the situation in Karnataka. Now, 30 is important. As regards the situation in the Karnataka Assembly, the issue before the court was whether the governor, on receiving letters from certain legislators that they were withdrawing support from the government, was justified in himself coming to the conclusion that the government had lost majority and giving a report under 356 for issuance of a presidential proclamation. It is pertinent to note that the Chief Minister in that case had offered to test the government's majority on the floor of the House. Chief Minister himself, I'll test it. These are the facts of Bomai, Karnataka, which they relied upon. In that context, it was held by this Honorable Court that in cases where the support to the ministry is claimed to have been withdrawn by some legislators, the proper cause for testing the strength of the ministry is holding the test on the floor of the House, because the Chief Minister said, I am ready to hold that test. And para 3 was there on that day of the 10th schedule. And what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There's no general principle that can be applied across the board. There can't be. Freedom of speech is a general principle. How you will actually, recognize it is the context. So, in this connection, it is necessary, I'm quoting, I'm sorry. In this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislatures, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test. and on relevant considerations. If you are able to justify that to the court, then the only remedy is a floor test. Well, the next paragraph, I just read the highlighted portion, para 391 at the bottom. Whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or, for that matter, anywhere else except the floor of the House, correct? Principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where the democracy is in action. It is not for the governor to determine the said question on his own or his own verification, which is what exactly he did by recognizing a faction. Now, let's kindly come to para 32. Thus, S.R. Bommai is not an authority for the proposition that the governor must order a floor test whenever a claim is made that the elected government has lost the confidence of the House, irrespective of whether such claim is based on unconstitutional or extraneous considerations. Rather, S.R. Bommai, it was categorically held that the power under 356 cannot be used to... I just waste, we have a short time. My colleague has to also. I don't want to hog everything. Rather, in S.R. Bommai, it was categorically held that the power in 356 cannot be used to sort out internal differences in or intra-party problems of the ruling party. Para 82. If your lordships will just allow me to show that, if it's convenient. Well, I'll show that here. Volume 2.
There's Bommai?
Yes.
We'll read Bommai here. You have extracted it.
Yeah, I've extracted it.
Yeah, we'll read it from your extract. Much easier. We've got Bommai, of course.
Yes, I purposely did it, Mala, so that otherwise you'll have
we don't have to go back and forth at all.
You have extracted it also.
Yes, I've extracted it. It's okay. Well, it's actually, I must give credit to my colleagues.
Yes.
Well, it's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. It's extraordinary. And I owe gratitude, sense of gratitude to them. Sort out internal differences or inter-party problems of the ruling party, and that exercise of this power for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution would be vitiated by legal mala fides. You're now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he is the leader. So the governor is recognized. I'm sorry.
Will just give us a moment. There was an urgent order. Which
No.
I'll just show it to my learned brother, Justice Narasimha.
That's the morning,
yes.
Yes, sir. Okay.
24th March only. Thanks.
And this intra-party quotation is from Sarkari Amalat. It is adopted by Bommai. And it is consistent with those propositions, Malaj, that I read to your lordships of Sarkari Amalat adopted by Rameshwar Prasad. So you can't enter into an moment you say, okay, I'll recognize these three people, I will entertain these two people, and then now you have lost majority, now you have a floor test. So impermissible. That's the old non-10th schedule regime, the Ayagram, Gayagram regime. Then, crucially, para 34, S.R. Bommai, Justice Jeevan Reddy further observed in the context of the 10th schedule that we're equally of the opinion that the High Court was in error in holding that the enactment of a 10th schedule of the Constitution has not made any difference. The very object of the 10th schedule is to prevent and discourage foreclosing and defections, which at the time had assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of a division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in the case of a split, a legislature has to report his party willy-nilly.
So, Sybil, the only problem is, I just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in the. Which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue. The government has to continue. It's basically reduced to a complete minority, probably.
Your Lordship is absolutely right. May I answer that, Malaj? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaj. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose confidence of the House, Malaj? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Narasimha Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister. You become a chief minister. Use the governor's office for that. Your Lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers. We have reduced ourselves to that we are mocked. People don't believe us anymore. Anyway, so
now we go on to Shivraj Singh.
Then Shivraj. Respondents relied on the law in Shivraj to contend that where the governor has reason to believe that the incumbent government does not possess the support of the majority, the correct course of action would be for the governor to call upon the chief minister to face the assembly and to establish the majority of the incumbent government within the shortest possible time, irrespective of the fact of disqualification. Well, I just read the highlighted portion. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. Well, as I read the beginning, as a matter of constitutional law, it would not be correct to proceed on the basis that the constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised on the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called into question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. So we are not against the floor test. We're against the considerations on the basis of which the floor test was ordered. It is respectfully submitted that Shivraj Chauhan, there are no disqualification petitions. Now, this is the other thing, pending against the MLAs whose resignation was under consideration. As noted by the Honorable Court in para 41, notices of disqualification had been issued against 6 MLAs on 13/3, but the Speaker had accepted the resignation of these 6 MLAs on 14/3, which I mentioned to your Lordships yesterday. As regards the other 16 who had tendered their resignations, the Speaker had not yet accepted their resignations. When the Governor directed a floor test to be held, the disqualification petitions were not pending against MLAs whose resignations were under consideration when the floor test was held. On the other hand, in the present case, Governor's decision to direct a floor test to be held on 20, knowing full well that the very MLAs of Shiv Sena Legislative Party who the Governor had recognized are facing disqualification. Furthermore, this Honorable Court's observation in para 80, the pendency of proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test, are premised on the constitutional principle that neither the Court nor the Governor has any right to impinge on the Speaker's power to decide on the issue of disqualification. This Court cannot say that you cannot decide, or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the Court. It is straight law that neither the Governor nor, for that matter, this Court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. Well, now 5 judges have said that. Therefore, that order on the 27th put us in a situation, where the elected government was toppled. Neither the Governor nor, for that matter, the Court can entrench upon the power of the Speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue, and there cannot be any Kitemek order. Then, whereas in the present case, the decision to hold the floor test was taken by the Governor on 28/6, by which time this Honorable Court had already interdicted the disqualification proceedings against the respondents on 27/6. The Governor, being aware of the pendency of the disqualification petitions and being aware of the fact that this Honorable Court had extended the period of filing a reply on 2012, could not have disturbed the status quo in the Assembly by directing a floor test. Para 82 of this Honorable Court noted, nothing prevents the Speaker from taking a decision either on matters of resignation or of disqualification despite convening the trust vote. Even in Shivraj Chauhan, your Lordship said, because there was no interdiction there. So the Court said, in Shivraj Chauhan, the Speaker could easily disqualify. But in this case, what happened? The Speaker could not move. So how does Shivraj Chauhan, an authority for the proposition that a floor test is necessary in these circumstances? The illegality of the Governor's decision on 28/6 cannot be remedied by subsequent event or actions. The respondents have sought to justify the Governor's decision dated so-and-so by relying on Uddhav Thackeray's resignation on 29/6 instead of facing the floor test. Further, it has been contended that even the votes of 42 MLAs were excluded. We are still through. That's not relevant. When Bomai was decided, and Bomai set aside orders under Article 356, what did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your Lordship that what Bomai said was the acts that have happened in between can be validated by the Court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the Chief Minister Mullahs by setting aside the order of the Governor. So we are not saying, Mullahs, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your Lordships decide one way or the other. Anyway, Mullahs, I'll just quickly now. Then Mallards, kindly come to 46. S.R. Bommai and Union, the court, while considering the legality of a presidential proclamation under 356 that has been subsequently approved by both houses of parliament, held that an invalid proclamation would nevertheless have to be set aside. So this argument, Mallards, that is according to an argument of frustration. Because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the house. All irrelevant. Bommai says so. Held that an invalid proclamation would nevertheless have to be set aside, thereby recognizing the principle that the legality of an act must be tested on its own terms, and acts consequent thereto cannot give the color of legality to an action which is illegal. I've given the paragraphs, Mallards. Further, Bommai holds that upon invalidation of the proclamation under 356, the natural consequence is to restore the status quo ante. Court may, however, mold the relief in respect of subsequent acts, but when restoring the status quo ante, the court must restore the Council of Ministers and the Legislative Assembly as they stood on the date of the issuance of the proclamation. Otherwise, the remedy of judicial review would be rendered meaningless. How much more eloquent can the court be on this matter? In fact, Bommai goes on to say that holding of fresh elections can also be injuncted on the principle that such a relief is to prevent the frustration of the constitutional remedy. It further goes on to say that the court may be duty-bound to give an interim order of this nature to make effective the constitutional remedy of judicial review and to prevent the emasculation of the Constitution. Well, what's the point, Mallards, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? Additionally, Mallards, it is settled law that the village, let's leave that out, Mallards. So, Mallards, para 52, the legality of the governor's decision has to be determined with reference to the decision itself, not by reference to any subsequent events or facts. There is no constitutional basis for the proposition that the otherwise illegal decisions of the governor can be justified by referring to subsequent events and actions, including the fact that the petitioner participated in the floor test on the 4th of July. Then governor's decision on 30th of June to swear Eknath Shinde. That's the next. It is respectfully submitted that governor does not have the power to invite a leader of a faction of a legislative party, acting dehors the political party. But where does the governor get this power from? Who is he recognizing? Leader of what? The governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the Election Commission. The leader is as communicated to the Election Commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Mallards. In the instant case, it is undisputed that on the 30th of June, Uddhav Thackeray was the leader of the Shiv Sena political party. However, the governor extended an invitation to form the government of Shinde, whose only claim as on 30th June was that he is the leader of the majority faction of the Shiv Sena legislature party. The governor, as on 30th of June, did not and could not have recognized Mr. Shinde as a leader of the Shiv Sena political party. As submitted above, a parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of the legislature. Mallards, I've already said that. As submitted above, therefore, the governor's action of inviting Shinde, Mallards, to form a government illegitimately recognized an alliance between a faction and Shiv Sena legislative party and the BJP, which is constitutionally impermissible. The governor's decision is liable to be set aside on this basis. Further, the respondents have failed to deal with the petitioner's reliance on 164(1)(b). Mallards, let's leave that out for the moment. Let's leave out the other things. Then, Mallards, they relied upon Kuldeep Bishnoi. What I have now done is, Mallards, I've given your lordships para 62, what Kuldeep Bishnoi held and how it's wholly irrelevant, Mallards. So that I don't have to, Mallards, unnecessarily take your lordships. I've put it out in the note itself. And then Shivraj Chauhan. Then come to respondents. Now, this is the next topic. Next topic is page 20. Item C, respondents based on undisputed facts on record have incurred disqualification under 2(1)(a). Petitioners have shown that the undisputed facts of the respondents, namely so-and-so, passing a parallel resolutions. I will let Dr. Singhvi actually deal with this because originally also he had dealt with it. So let's sort of. Then C1, repeated, now respondents contend that now repeatedly saying that there's been a split and you have not merged is of no consequence because there is no one, this is no one's case. I have never argued that I have split from the political party. I'm just quoting from the transcript, how useful this transcript is. I have never argued that I have split from the political party. We have never argued that we needed to merge with other parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we are within the Shiv Sena, represent the rival faction. Now he's accepting it. Representing the rival faction which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he's saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself, what political party? So I'm quoting only from the transcript. And has now been recognized as a political party is in question is in this matter. Then, I've said the contentions of the respondents never claimed that they are a faction of the legislature, but they are a political party itself is totally misconceived. After the deletion of para 3, a faction, I've already said that. Effect of deletion is that a faction, as soon as it indulges in prohibitive conduct under para 2, would have no defense available. So they have no defense available. Respondents' justification in substance is that they are the majority faction in the legislature party, which is no justification in the eyes of law. Respondents cannot avoid the inevitable consequence of disqualification. Legality of respondents' actions is to be tested based on substance and actual effect on the impugned acts. I will not deal with it. Now, let's forget about this election commission for the moment. Now come to C3 at page 22. Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities, and to prevent acts which would amount to disqualification. That's the whole purpose. The Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. In furtherance of their smokescreen defense of being in Shiv Sena, the respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I'm a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party. That is how it has been right through the whole artificial distinction which has been drawn, that is that the legislature party who did it and the political party had nothing to do with it. I have never ever said that the two are different. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Thus, In substance, the respondents contend that the faction representing a majority of the legislature party is deemed to be the political party without regard to the political party which has been registered by the Election Commission under 29A. A fortiori, therefore, without referring to the original political party which has been registered with the Election Commission, the majority faction contend that they can hold themselves out as a political party and take actions within the House, dehorse the political party on whose ticket they were elected. It is submitted that a majority faction cannot claim that they are the political party registered with the Election Commission under 29A of the Representation of Peoples Act. There is nothing in law which allows such a claim to be made. Distinction between the legislature party and the political party is reflected in the provisions of the 10th schedule. Submission of Eknath Shinde Group is contrary to the clear provisions of paragraph 1 and paragraph 2 and the explanation. I have read it to your lordships for this. I will not trouble your lordships with that. Then I only come to Now, para 83, if the respondent's submissions were correct or were to be accepted, it would create chaos within the political system with functions within the scheme of the Constitution as provided for in its various provisions, including the 10th schedule. So, Mullahs, now come to C4. I will leave the rest, Mullahs. Now, Mullahs, your lordships will remember all this happened much before the matter went to the Election Commission, because there they moved on 19th July. So, Mullahs, all this is so per se unconstitutional. Now come to right to dissent. The respondents have claimed that the 10th schedule cannot be used to stifle dissent within the party, and definitely internal dissent does not amount to voluntarily giving up membership of the party. Well, this whole argument was raised in Quixote in the context of Article 105 of the Constitution, not in any other context, and it was rejected. And 105 of the Constitution, Mullahs, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. Respondents have claimed the 10th schedule cannot be used to stifle dissent. Then at the outset, it is respectfully submitted the said contention is in complete violation of the decision in Quixote, where this court specifically considered and rejected the argument that provisions of the 10th schedule violate the freedom of speech and conscience of the legislatures. It was held that people have grown distrustful of the emotive political exultations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. This court is distrustful of that, is what Quixote says. The 10th schedule, it is urged, negates those very fundamental assumptions of parliamentary democracy, of freedom of speech, of the right of dissent, and the freedom of conscience. This was urged by Mr. Jethmalani. It is urged that this unprincipled political defections may be an evil, but it will be the beginning of much greater evils, of the remedies graver than the disease itself were adopted. 10th schedule, they say, seeks to throw away the baby with the bathwater. So, Mullahs, all this I don't have to go through. And then, Mullahs, this went on. I will not trouble your lordships. Kindly come to para 44. Para 44 is what. But a political para, page 27, functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independently of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is its source of sustenance. And then, Mullahs, Mullahs, para 47. Mullahs, this is a quotation from Rodney Brazier. Once returned to the House of Commons, members' party expects him to be loyal. This is not entirely unfair or improper, for it is the price of the party's label which secured his election. Now, my lords, this loyalty is for a price which has secured him the chief ministership. If I can put it, my lords, differently. Then, my lords, para 49. Well, it's the highlighted portion. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful of the emotive political exaltations that such floor crossing belong to the sacred area of freedom of conscience, or of the right to dissent, or of the intellectual freedom. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation have been the bane of the times. This is recognized by a constitution court. Above certain theoretical assumptions, which in reality have fallen into a morass of personal and political degradation. And this particular litigation is a shining example of that political degradation. We should, we think, defer to the legislature's wisdom and perception, saying we know the reality, and that's why the 10th schedule, that's why they must not crossing the floor must not be allowed. And then Bomai, whatever may be his personal, I've already, Malads, personal this thing, I've already read that, so I will not trouble your lords. Then, Malads, now, para, respondents based on undisputed facts on record of incurred disqualification. I will not do that. I let my learned friend deal with it. I actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of theirs, which is undisputed. 21B, of course, but that's afterwards. Yes. Then, Malads, now, E is the decision of the Election Commission under para 15 cannot efface the disqualification income. But whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification. That's the purpose of this particular paragraph. So, Malas, I will. Then the order dated 27/6, interdicting proceedings before the Deputy Speaker, in effect, created a hiatus in the operation of the 10th schedule. I've already, Malas, dealt with that. So I won't trouble your lordships with that. And then the list of dates. Then the only thing I have to now, Malas, is to go back on my written submissions. On my written submissions. Original written submissions. Yes. Now, Malas, I want your lordships to look at the chapter relating to whip.
In your rejoinder?
No, Malas, my original submissions,
Yes.
chapter relating to whip, that is PDF page 70 in my written submissions.
70.
On mine.
70.
70. So just have a look at
Chapter 7.
Yes.
Chapter 7 on whips. And Malas, they did not address your lordships on this at all. The only thing they gave was that document which I showed to your lordships yesterday.
Only one thing which they have said about
Yes.
whip is
Yes.
that they have referred to the disqualification rules.
Yes. Oh, yes, I have to deal with
And,
that.
perhaps you may want to.
I'm sorry, I
that.
should. In
That's
my,
related to 3-1.
I'm going to show that immediately, Malas. That's my mistake. I should have, in my desire to finish quickly, Malas. Kindly go to those disqualification rules. There is compilation, Malas.
Rule you will have to.
Yes, statute compilation. F. This is PDF, Malas, page 6. Thank you, Malas, for reminding me. I should have dealt with it.
We have some doubts, so.
Yes.
Yes.
Malas, definition of leader. Your ladyship has it, my lord has it?
Yes, we have it.
Leader in relation to a legislature party means a member of the party.
What is he referring to?
He's reading Maharashtra, this thing.
तो ठीक है, कोई बात
First bookmark,
Page
page 2,
नहीं। हाँ, 1 बजे कर लो।
rather 4,
5 and 6.
definition.
तुमको भी टाइम मिलना चाहिए
Definition.
यार।
Oh, okay.
हाँ।
Yes. Thanks.
So PDF
Yes.
6.
Yes.
See, leader, Lordship has that now?
Definition of
Leader in relation to a legislature party means a member of the party chosen by it as its leader. Chosen by the party as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, brothers. And includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, brothers, with all my contentions. This is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. So this argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amalas, yesterday, an argument was made, how could they whip act outside the house? Amalas, what were they doing in Assam? Appointing a whip outside the house? They made me a serious argument yesterday. This is a whip. How could they do it outside the house? So you're sitting in Assam in the lap of the BJP, and you are displacing a whip which is recognized by the political party and conveyed to the speaker. And these office bearers are there on the record of the register of the assembly. And you say Gogavle is the whip. I mean, it's per se voluntarily giving up membership. You say I continue to be the leader. On what ground? You've been removed on the 21st of June itself. So how are you the leader? Well, let's kindly look at it this way for a moment. Well, supposing I say I am the party, what should I do? I should go to the party, call a meeting. There are rules of the party. Go and establish your majority in the party, and then become the chief minister. There may be no dispute in the legislature party. Take a case, Malas, where there's no dispute in the legislature party. What would a person do if he says that, look, I am the party? He will go to the party. He can't do it any other way. Now, if you are able to galvanize the support of X number of members, there may be minority, there may be majority. And then on the basis of those numbers, you destabilize an elected government, and then go to the election commission, and on the basis of the fact of those very people who are subject to disqualification, get the symbol and then say, I have the party. Which of the two procedures would be constitutional? Constitutional law, members of the legislature can never be given primacy over the party. Can never be given. Because they are individual members, Malas. Group means you may actually act together, that's not relevant. So, Malas, this is one part that they relied upon. Then para 3.
3 must be read in terms of.
Yes, exactly. I was going to read that, Malas. That's at page 5. The leader of each legislature party, other than a legislative party consisting of only one member, shall within 30 days from the date of commencement of these rules, or where such legislature party is formed after such date within 30 days from the date of its formation, or in either case within such further period as the Speaker may for sufficient cause allow, furnish the following to the Speaker: a statement in writing containing the names of members of such legislature party, together with other particulars regarding such members as in Form 1, and the names and designations of the members of such party who have been authorized by it for communicating with the Speaker for the purposes of these rules. Clearly, Manoj.
It is in the definition also.
Yes. Then, Manoj, my Lord the Chief Justice asked a question, or one of your lordships asked him a question. Is the whip mentioned in the form? And the answer is yes. The fact is it is not. Kindly see the form now. He gave the answer as yes. Page 13.
Whip is by convention, is it?
Yes, absolutely. It's not even there. Party affiliation, that's all. Item 5. Date of election, date of signing of the form.
Which form is this?
This is Form 1, Malaj.
Form 1. Name of the legislature
That's
party,
all.
name of the corresponding political party.
Yes. There's no question of whip. No question, Malaj. That's something that's appointed by the party.
Page 5.
Page 11.
Page 11, your ladyship may have. Page 11, Form 1. PDF 13. So, Malaj, it's crystal clear. Which is why, Malaj, they very strategically did not refer to all that I had said about the whip. Not mischievously, strategically. Huh? Yes, Malaj. I was on petitioner's written submissions on this, Malaj. Yeah. Petitioner's written submissions. I got it. Yeah. That's at PDF, Malaj, page 70.
It's for lunch because we'll relax a little.
Let me see PDF, Malaj, page 70 of on whips and the role of political parties.
Yes.
So, Malaj, he said there's no distinction between legislature party and political party. See the definition. Subject to provisions of paragraph 4 and 5, a member of a house belonging to any political party.
Where are you reading?
Page PDF 70 in my written submissions.
On whips and the role of political parties.
Yes. Of which, Malaj, they didn't deal with it
You
at
have
all.
read in detail, Mr.
I'm sorry?
Well, that one you had read very much in detail.
In fact, we've highlighted.
Originally, yes.
We've highlighted that.
I highlighted the history, how a whip was, all that I said, but they didn't deal with it at all. Their argument was, no, the legislature party appoints the whip. And they gave that document to your lordships, which is contrary itself to the record, because that's a Rajya Sabha member appointing with it. So, that's, I've done with this part of it. Now, a bit about, Nabam Rebia, if your lordships will permit me. As far as Nabam Rebia is concerned, Nabam Rebia does not take into account the ambit of Article 179 of the Constitution and the concept of removal in 179. We'll see that. First, 179C.
Does
He
not
be
take into
removed
account
from it.
the concept of removal in Article 170.
Yes, removal in 179C, Malaj, not dealt with at all In that context, yes, kindly have a look. Provided that no, it's like not a no confidence for which no reasons have to be given.
May be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly.
Intention to move. Intention to move. Your Lordships will remember
Yes.
the submissions that I had made. The question of moving doesn't arise. Intention to move. So that concept, Mullah, is not dealt with in Nawam Rebia at all. What does Nawam Rebia say on the issue of 10 members, Mullah? My learned colleague, Mr. Jethmalani Mullah, said that seemed to be an erroneous interpretation. 10 members means then who are members of the House at that point in time. That will exclude people who are disqualified. But Nawam Rebia says, no, you can't change the status of the House, even if there are disqualification. In a sense, saying that you can't even deal. The Speaker can't deal with disqualification petitions. That's Mullah's also an area where Nawam Rebia Mullahs did not deal with it. That's the second. And the third is, Mullah, just look at this notice. Please show where the notice is. Notice which we were given. Para 235 or what?
Nibam. Nabam.
No. I am talking about the concept of removal. I'm not talking about, we are not here talking about whether the article is referred to or not. We are, no, not the ground. This is the whole point. That issue was never raised. It was me. Many things you have said happened but didn't happen. So let's not go into it. Well, there is no discussion as to, well, kindly, there's a difference between notice for removal and a mere notice without any grounds for removal. See the notice here.
Yes, can we see the notice?
Yes, that's so important. Yes, I know, I've already said that. Convenience compilation, 2 Mullahs. Page 62 Mullahs, PDF. It's very interesting.
PDF page?
Page 62 Mullahs.
62.
Now, Mullahs, kindly see. Just have a bare reading of this notice, you will find out, Mullahs. You realize the fallacy of the decision in Nabam.
Running into 731 pages?
Notice.
Oh,
PDF page 60.
This is that one, Mullahs, which it is dated 21st June, but Mullahs received by the secretary, the secretariat at 11:33 on 22nd June.
AM.
Yes. Says you were, my lords have it?
Yes.
You were elected as Deputy Speaker of the Maharashtra Legislative Assembly in 2019. Since February 2021, due to resignation of Nana Patole from the post of Speaker, you have been discharging functions. We all respectfully submit that you no longer have a right to continue as Deputy Speaker. What kind of notice is this? For my removal? It's well-known judgment of the Supreme Court, so they rely on Nawam Rebia. They misinterpret Ramam. According to me, Mullahs, this could not have been the law in Nawam Rebia. Could never have been. They write a letter saying, now, I want to remove you. That's it. It's not a no confidence motion. It involves, Mullahs, consequences, civil consequences. I am holding an office under Parliament. I am removed from that office. I am not told why I am being removed. Yes, that's why the Constitution says at the time when the Legislative Assembly is in session. Remember, I read that? At that time, if it is moved and it is under consideration, only on that occasion I cannot sit. I have to go down to the House and I can participate in the proceedings and put my point of view. The procedure itself tells you that inherently in this process are reasons for removal.
What you're saying is simply saying no longer enjoy the support of the majority of the House means nothing. This is what you're
Yes.
saying.
So well, Nabam Rebia has to go. It's in that context that I mentioned 179C, Malas. So, Malas, I've done with that. Now, I just want to read, Malas, their letter of the 21st of June, that resolution. Your Lordships, you just permit me. I won't take much time now. Almost done. Which way is that document? Convenience compilation 2, page. Section 2, page 55. That PDF 55, Malas.
PDF 55.
55.
55.
55?
Okay.
55. 55 only.
Is that right? No. PDF 55. Okay. Yes, Malas. Can you kindly have a look? Read with me this.
ये कहाँ है?
Page 42. 42 only.
42.
Yes. Page 55, volume 2, Malas.
42.
Page 55.
Okay.
So, Malas, this, first of all, this is written when? When this group, whether it's 34 or 39, are sitting in Assam. They know on the 21st of June that Eknath Shinde has been removed. Right, Malas? So it is in that context that this document is written. So obviously it's a self-serving document. It is not a document that sees the light of the day prior to 21st of June. It doesn't talk of any event prior to 21st of June. It makes some general statements that our cadres are unhappy. It refers to no such event. It refers to no such event when he has aired his views publicly prior to 21st of June. It refers to no such communication to the Chief Minister or to the party office prior to 21st of June. It's a self-serving document to justify the switch to the BJP. On account of corruption in the government. But till the other day, till 21st June, he was the minister. And he was the group leader. No. Sorry. And corruption is not relevant, Malas, as your Lordships have already heard in Boma itself says, corruption not relevant even for 356. Forget about this. So, Malas, what's the credibility of self-serving statements of a document when you're sitting in the lap of the BJP in Assam, knowing full well that you have been removed as a group leader and that Ajay Chaudhary has been appointed? Now, Malas, kindly see the end of this document. PDF 58. In view of the above, I'm sorry, my lords have that. In view of the above, the members of the Maharashtra Shiv Sena Legislature Party have met today, Legislature Party, and resolved as under. Hence, it is unanimously resolved as under. It is hereby resolved that and reaffirmed that Eknath Sambhaji Shinde, who was appointed as a leader of the Shiv Sena Legislature Party on 31/10, is and continues to be the leader. Why continues to be the leader? He is the leader, if he is the leader, because he knows he's been removed. And then it is hereby that Bharat Gogavle elected is appointed as the chief whip, and that Sunil Prabhu's appointment is cancelled. Well, sitting in Assam, 34 people or 39 or whatever, cancel the appointment of Sunil Prabhu. Which procedural law is this? He's been the whip since 2019. So it's a self-serving document. No credence can be placed on it. There's not a mention of a split at all. It's the decision of the legislature party. So no split, self-serving document, and relied upon to show that there was some enormous discontent that was happening, reflected nowhere in the document with respect to any fact that's stated. And governor says that this document shows I am in receipt of resolution of 21st by 34 members stating that there is enormous discontent. Resolution clearly indicates that the majority members of the Shiv Sena legislative party want to exist the alliance of the NCP and INC, and to that end they have reaffirmed the appointment of the leader of Shiv Sena legislative party. He is recognizing a person who has been thrown out, the governor. With greatest respect, Malad, this cannot be countenanced. You have to completely disregard this document as a self-serving document with no indication. And therefore, Malad, Justice Venkachalaya's observations only, Malad, reaffirm that we have reached the bottom of the barrel. So, Malad, I mean, I didn't want to say this, Malad. I really did not want to say this. But I'll give to the other side. You just have to read it, Malad, where we are going in this country. Give it to Malad. Read, just send it to Malad. Just give it to the other side. I will not read it aloud, Malad. This is a communication by the governor to Uddhav Thackeray. Just give me a few more minutes. I'll have done, Malad. Give me just a few more minutes. During COVID times, and kindly come to the second page, third paragraph from the bottom. Second paragraph from the top, Malad. The last three paragraphs. Just read them, Malad. Starting from I wonder. How does the governor write these things? This is the state of the nation. Mullah, last thing I'd like to say, and then I'm done, is that, Mullah, the history of this court is the history of celebration of the values of the Constitution. There have been occasions where, Mullahs, like ADM Jabalpur, Mullahs, which is in dissonance with what this court has done over the years, Mullahs. I wish and hope, Mullahs, because this is an equally, Mullahs, significant case. It's a moment in the history of this court when the future of democracy will be determined. Mullahs, I am absolutely certain that without the intervention of this court, our democracy will be in danger because no government will be allowed to survive. It is with that hope, Mullahs, that I make this plea to your lordships to allow this petition and set aside the governor's order. I'm obliged to your lordship.
Thank you, Dr. Singh. Dr. Singhvi will continue at 2 o'clock.
2 o'clock.
So how long will you take?
About an hour.
About an hour?
A little bit for Dr. Yeah, let them, Mullahs.
Thank you, Mr.
I am, Mullahs, honored by the
We'll give you an hour at 2 o'clock.
Deeply obliged. Before Dr. Singhvi starts, Lord, I was told Mr. Sibal, some unconnected letter was produced by him, Lord, written by the governor.
That you need not deal with. It's you want to have
Please-
to get a letter, just see the letter. No,
I have seen it, Lord.
it has no
I do
bearing
not-
on the matter. It has no bearing on the matter at all.
Lord, difficulty is I don't have the advantage of being in dual capacity. I'm only a lawyer. So I can't argue political issues, which are totally unconnected.
This letter was only, we had to only smile. That's all. Nothing more than that. I mean, there are so many things which I told you at the end of the argument. You just smile. You take it as
Lord, your lordship should smile twice. A, for such an unconnected thing being presented before your lordship, and second, for the content of. Lord,
I don't think you have to really take it.
I'll leave it at that. Lord, second thing, yesterday I
We're
forgot.
not even going to. I don't think even Mr. Sibal expects us to refer to it in our judgment or anything like that. Not
Even he
at all.
has not
Lord,
read it.
second thing, Lord, I
He didn't
forgot.
even read it as Brother Shah says.
He has not even read it.
He has not read it.
He said contents I will not read, you read.
Yeah.
Lord, second thing, I forgot to mention yesterday. In my list, I'm not arguing, Lord.
Yes.
In my documents, the last two documents are the letters received by me, by the governor, from leader of opposition and from Eknath Shinde, that this is how we have the stable majority. Allow us to prove it.
Okay.
So, my lord, kindly have that, my lord. And the third request, Lord,
Yes.
there are some new points, my lord, addressed by Mr. Sibal. Considering that this is a wider issue, my lord, I can't object to that being argued. But allow me to file, my lord, my summary of submissions, my lord, over and above what I have filed. After the arguments are over, not for arguments purpose.
We'll see. Or you
And-
want to make some point in 2 minutes, you can make the point in 2 minutes. They're
Lord,
also
I'll,
here.
no, it,
Suppose you filed your summary, then they'll say, well, we want to file something. If you make that
Lord,
point.
I would ensure your lordship
Sir,
that
if you make the point in their presence in 5 minutes, they're here, so you can, you're both in
I'll just-
presence of each
I-
other.
I bow
It's
down.
better, isn't it?
Lord, I can assure your lordship, there would not be anything new which they would feel that they need to
But
argue.
what is the problem, my lord, with saying it now? My lord is allowing you to say it in 2 minutes now.
Then after you complete.
After, Dr. Singhvi, after you complete, if there's, no, 1 second, if there's. if
But
they
this would be,
produce-
the ping pong will continue.
Give
That's
them
the
a
only
minute or
thing.
2 minutes.
Ping pong has to end this side, Balaz.
If,
The rejoinder is where the
Dr.
ping pong
Singhvi,
ends. Let him
will-
say that.
No, no, the
minute or
ping
two
pong
minutes.
ends where,
A minute or 2 minutes, if there's something which the,
Whereas your lordship's fond hopes of minute or 2 minutes or 5 minutes are difficult hopes to manage. 1 or 2 minutes,
Well,
5
Dr.
minutes.
Singh, we would rather have it said in your presence, so we don't have more
No, no.
pleadings now being filed in
I
the
am
form.
saying-
I bow,
Say it now.
I'll not insist for that. I'm respectfully, my lord,
I'm
not
saying say it
insisting
now.
for
I'm
that.
not opposing it.
Lord, let Dr. Singhvi complete.
Then you
If
see
there
what-
are some issues which
All right.
I as a governor cannot deal with, my friend will deal with.
That would be a sur rejoinder. Let him say it now. I'm not opposing his saying. Your lordship is permitted to say it.
No, no, after
Is not formed.
dealing with
He
your.
he may be wanting
okay.
to reflect on it for a couple of minutes. That's all.
Some paras I'll point out at the end which were
No,
not.
no, this will be a sur rejoinder. This is not.
Whenever your lordship says. So
All
I'll
right.
read it.
We'll see.
Unless your lordship will allow a note. Otherwise, your lordship will have a full-blown sur rejoinder in terms of 2
We
minutes.
thought
5
allowing a note would be prejudicial to you. Therefore, we said we'll hear them in.
He's agreeable, he's fair. My lord,
There'll
he's
be a sur
agreeable.
rejoinder. There'll be a sur rejoinder.
All right. Mr. Call, you circulate a short note.
Not more than 2 pages, yes?
Not more than 2 pages. Give a copy to.
That's fair, that's fair.
Very
May I
fair.
just make one suggestion, subject to what your lordship says. I'll take exactly 2 minutes by the clock and just give the paragraphs. Can I do that?
That can be in
Only
the
2
note.
minutes.
That can be in the note.
Only 2 minutes, that is,
That is
that is in para 119, my lords, of Bomai. Specifically the issue of legislators withdrawing support is taken care of. Bomai was a case of two parties merging and then a few MLAs withdrawing support. In para 119,
Just
It
one
is-
second. We'll just make a note of it. Bomai,
para 119,
just 1 second.
PDF
Page.
368 of the compilation, volume 2.
Yes.
It is specifically said in para 119, in this connection, it is necessary to stress that in all cases where the support of the ministry claimed is to have been withdrawn by some legislatures, the proper course for the testing the strength of the ministry is holding the test on the floor of the House. The only argument that I'm seeking to make, my lords, that this is a flawed argument from the other side, as if there is an alternative mandatory mechanism provided. Under the Constitution, there is no alternative mandatory mechanism provided to say that this should have been done and not that. When a governor looks at a position where MLAs come forward and say we are withdrawing support, to say that till yesterday you were together, today you are not together is not after Rameshwar Prasad the mandate of the governor at all, because that amounts to getting into the ethicality and the correctness of who should be with whom. Just testing the proposition, the BJP and the Shiv Sena were pre-poll alliance. Now someone could say post-poll, wasn't it unethical that for 30 years you were together and you ditched and went with someone else? I'm not getting, now that's not the governor's domain.
Okay.
All that the governor sees is,
that point you made now.
the governor sees is, do you have the majority or not, close it on the floor of the House.
You have cited. Then what is?
Secondly, my lords, para 191
Of?
Nabam Rebia.
Yes.
Read with para 233 to 235 of Nabam Rebia.
33?
233 to 235 of Nabam Rebia specifically deals with Article 179 subclause C and removal. It is absolutely incorrect to say that Nabam does not deal with removal at all. Para 191, 233 to 235 specifically deals with Article 179 subclause C and removal. Thirdly, my lords, para 238 of Nabam, because this whole argument of intention to remove, actual removal, Justice Mishra deals with it and says, you will not wait till the date when the resolution is moved. The moment an expression of interest is given, an expression of interest is bound to be by way of a notice. The moment that notice is given is when the clock starts ticking, because between the intention expressed to remove and the actual resolution being moved, you can actually alter the composition. So that's dealt with, my lords, there. Lastly, my lords, this whole, last just two arguments. Form 1, what I had mentioned, my lords, was when your lordships had asked me in that context, that is any post mentioned? There is no post mentioned there. So the purpose of what I wanted to say to your lordships, maybe I should have made myself clearer, is that under Rule 3, just show me Rule 3, that where designations are given, where it says a statement in writing containing the names of members of such legislature party together with other particulars regarding such members as in Form 1, and the names and designations of members of such party who have been authorized for communicating with the speaker is given by the leader of the legislature party. And if your lordships were to have Form 1, it is, just have Form 1 for a minute. Page.
Is furnished by the leader of the legislative party.
Yes. And then it says name of the corresponding political party. So and then lastly, my learned friend made an argument. Please come to that party in the beginning, just quickly, that party. Well, let's please see how is it being read. Firstly, please have G, 2G for a minute. My lords have
Doctor.
2G.
Yes.
Member means a member of the Maharashtra Legislative Assembly. Then F says leader in relation to a legislature party means a member of the party chosen by it as its leader, and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge of the functions of the leader of the party for purposes of these rules. My learned friend wants your lordships to read this, devotes the rules and say it means political party. And now please have Rule 3 for a minute. Subclause 5, just have rule.
Leader refers to the person who is designated by the party.
By the legislature. A member can only be the leader of the legislature party. That's what I read. no one else other than a member of the
No, but see
legislative.
the definition of leader, it's very clear. It is
Yes, yes,
designated
state
by
actor.
it means by the legislative,
Yes,
the political
Manoj.
party.
Political party.
No, it doesn't use the word political. That is your interpretation.
No, but this
No,
is
no,
very
it-
clear. This is
Yes.
very clear. Just read the rule.
Please read
Yes,
that.
the rule
See the
is
definition.
In relation to a legislative party means a member of the party chosen
Yes.
By it.
as its
yes.
leader.
By the party, according to us, here means that it's the MLAs who get together and elect
No,
leader.
no.
Cannot
Manoj,
It says party means chosen by
Manoj,
it
please
means
see.
by the political
No,
party.
Manoj, please see what 2G says.
And the word which says and includes, that makes it even more clear.
Manoj, may I?
And includes. Just read and includes.
Yes.
And including.
I'll just read that. For a minute, just have
Perhaps
2G
he
for
doesn't
a
want to
minute.
give a note, but he
Just a
wants to
minute,
argue
just have 2G for a minute. 2G, member means a member of the Legislative Assembly. Member means a member of the Legislative Assembly.
Right, has to be.
Then leader in relation to legislature party means a member of the party chosen by it as its leader. Manoj, it's the elected legislatures who choose a leader of the legislature party. Why learned friend is trying to say that somewhere else.
But leader, definition of leader.
Leader, Manoj, there is no, I don't think there's a leader. Yes, leader in relation to a legislature party means a member of the party chosen by as its leader and includes any other member. Any other member is a member of the legislature party of the party authorized by the party to act in the absence of the leader. Now, just for a minute for the completeness, just have rule 3, subclause 5, 5 for a minute. Just for a minute, my lords.
Definition of leader is 2F.
I read that. I read that.
3-5. Okay.
Yeah.
3-5, where a member belonging to a political party, any political party, votes or abstains from voting in the assembly, contrary to any direction issued by such political party or by any person or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, the leader of the legislature party concerned, or where such member is the leader or as the case may be the sole member of such legislature party, such member shall, as soon as may be thereafter, and in any case within 30 days from the date of such voting or abstentions, inform the speaker as in Form 2 whether such voting abstention has or has not been condoned by such political party, person or authority. Malad's leader is always by the elected members of the legislature party. When is a leader is always, for instance, the MPs get together, the MLAs get together to appoint the leader.
We'll consider that.
Anyway,
As was done in 2019, and then what is important for your lordships to know is
So according
what
to
is
the party means the legislature party.
Yes, and why I'm saying so is, my lords, everyone understood it to mean so because that was the party convention right through. That was a question, my lord, the Chief Justice put in the initial rounds of arguments, that there has been a convention because those letters were shown. They've also understood it to mean the same thing. This is now an argument being made to somehow get out of it. That's all that I wanted to say, my lord.
The leader conventionally in every party is elected by the elected members of the legislature, whether in parliament or not imposed by the party. Party means the political party.
it's a rule concept.
That's the only interpretation which is in tune with the democratic principles. That you have the electorate voters, they elect MLAs, MLAs elect their leader, and the leader is responsible to the House and consequently to the voters. Because Constitution does not talk of political party at all.
I hope they leave something for their written note with us.
My lord, lastly, I'll just end by saying my learned friend had also argued that the letter contained no reasons for removal of the speaker when my lord Justice Kohli put to them that where is that letter, read that out. Now, my lords, one thing which has to be kept in mind is we are not dealing with a notice under disciplinary proceeding where someone should be given details of what is the case that he has to meet. The words used are for removal of someone. You categorically in detail para says you've lost the majority of the house. That's what Nabam said, that if you have confidence of winning the confidence, go and face it.
All.
Win the confidence.
All right. Yes, Dr.
Yes,
Sikri.
my lord, that's all that I wanted to say. I'm very grateful, my lord, for this indulgence given by you.
Now, Malaj, some of it my learned friend will answer, Malaj. At the end, that will take us 10-15 minutes. He'll cover that. But let me, Malaj, come to my first. Let me stick to my sequence. Just an aside, Malaj. All that was done in the last 10 minutes was reference to everything but the whip. The only issue relevant is whip. Your Lordship would be asked to turn parliamentary and party-based democracy on its head if you were told that whip is not issued by the political party. What your Lordship has shown just now is totally irrelevant and red herring because it is intimating to the Speaker and the House that in this House, my leader is so-and-so. That is a communication between those in the House communicating with the Speaker. Speaker has to know whom to communicate with. It is no communication of the party with its members. That's the whip. And that the party issues, the party decides. But that was apart. We'll come to those rules. So this is completely irrelevant. It cannot be anybody's case that in the context of a whip, the party, the political party is to be ignored and the legislative party is to be looked at. Now, but leave that aside. Let me go in my own sequence first. I'll come to that. Your Lordships ended before lunch with a simple finish with a flourish, about democracy. Let me just start with that. According to my respectful, I'll come 7, 8
You
heads.
follow the same note, Dr. Singh?
Now, on the note, I have an apology, little bit of a mix-up. My note came to me in the morning. I corrected it and sent it back. Somehow it didn't go through. So they have filed by mistake the old note, which I had not corrected. Luckily, sitting here, I found it, and I corrected it. It has been, we've got hard sets, it's been emailed, but your Lordship's uploading is in your Lordship's domain. So, the court master was told all this. So, your Lordship may have to either upload it or otherwise the hard sets. Because there's a mix-up, the uncorrected note came here. I made many corrections in that. So, this is A7. Lordship call it A7. And my learned friends have all got it. Free lunch.
old one remove कर देना.
This will be in substitution. I'm sorry.
Old remove कर देना.
This will be in substitution of A6. A6 is the wrong one, the earlier one.
6 is the wrong.
A6.
There is an
A7 is this. Region the final PDF.
expression of
ये
Richard.
remove कर देना.
Page
नया upload
48.
कर.
Let me just summarize orally and then I'll come to the note because it will be much easier to follow the crux of my submissions. May I start? Your Lordships have got one, either the hard copy or the soft one, whichever your Lordship is using.
Same है कुछ फर्क. Same. What is the change?
No, there are a lot of changes. Your Lordship may just take this one.
Starting is the same paragraph.
No, starting, but there are changes. There are a lot of changes. Lordship may junk the other one, otherwise Lordship will be confused with the other one.
So just comparing, but it.
No, there are changes. Lordship may just tell them, your Lordship's assistants to delete that earlier A6. That's all. Otherwise, there may be some confusion. There are whole sections which are added, etc. That's all right. Your Lordship will use this first. Now, the first submission, and I'm not going to follow this sequence. Allow me to oralize. My first of my 8 facets is something which is repeatedly fallen from your Lordships, and yesterday it fell directly from my Lord Justice Narasimha. That your Lordship is concerned about democracy, majority becoming less, or your Lordship use the word overwhelming numbers going this way or that way. This connects with that. Mr. Sibbal has answered in one way. I'm now giving your Lordship a different facet. Because my submission is that your Lordship has to go back to the origins of the 10th schedule. And first point under this head is that the 10th schedule has 2 components, not only one. One is a prohibitory negative code. It's a negative code. So a negative code is what you should not do. Violating of whip, voluntary resignation, cohabiting with other people, etc. But there is also an affirmative, positive part of that code. And what the 10th schedule does is to strike a balance between the negative and the positive by a constitutional amendment. it is my respectful submission, it is vital for your lordships to give effect to both negative and positive in letter and spirit. Because your lordship is actually implementing the constitution. And some of the arguments of the other side have bordered on suggesting that a mere, I'm using the word mere advisedly in comparison to a constitutional text, a mere symbols order will be competing with a constitutional text. That would be completely anathema to all known principles. What are these two codes, Balas? The negative code is that you, in a nutshell, I'm just saying, in a nutshell, I'm oversimplifying. You will not voluntarily give up membership to 1A and you will not violate whips to 1B. Just in a broad summary. What is the affirmative permissible activity? You are entitled to dissent only within that permissible zone. Otherwise, why enact the 10th schedule, Malas? Prior to 85, you didn't have the 10th schedule. You had Jungle Raj, which you called Ayaram Gayaram sometimes, but then you can also justify that in the name of free speech, free action. What you did here was you allowed a zone of activity, permissible, affirmative, but you cannot say that I will go beyond that permissible and thereby violate indirectly the negative code also. What is that permissible activity? The affirmative code of conduct. One is a faction or a split till the 91st Amendment. They gave you an escape route, advisedly, consciously. That has gone. It was there. So, the constitutional framers thought that along with a negative code of conduct, so as not to stifle you completely, we give you an escape route, exit route of faction or 1/3 or whatever it was called. Second, merger. Third, and this is actually the most important part of 10th schedule. Elections, barring a few cases, in the days of 1960s, etc., there used to be a very strong, large number of independents. Independents have now dwindled. The statistics show, even then, in terms of 545 Lok Sabha, you had hardly 30, 40. But independents commanded a coordination. My father also got into Lok Sabha on an independent party-less ticket. So I know that time it was Mr. Nath Pai, so many people. But today, even then, party democracy was, everything was based on party. You got a ticket and you fought and you won because the party projected you as its candidate. That is now, much, much truer after the 60s, 70s onwards. Today, the number of independents compared to the 60s would be a fraction. So it's party-based democracy. You like it or not, it's not for anybody to question. We've chosen it, there's nothing perfect. Some people say US is better, some people say European, but this is what we've chosen. Now, this third balance.
Third point is what? What is the point?
One is
split is permissible, merger
second
is
merger.
permissible.
Third now.
That's the third point.
Third comes with the light of what I said just now. The whole idea of the 10th schedule is resign and recontest. That's what is stopping you from doing. You enter the door through this door and then you retain your ministership and seat while exiting through the other door. Sorry, not permissible. Resign, have the courage of your conviction. Now, you are a very vocal freedom speaker. You have the courage of your conviction.
Which Justice Jeevan Reddy referred to in that extract.
I'll be dealing with some of
that. It was not in the context of the 10th schedule.
But I'll be dealing with that. Some judgments have referred to it. I'm going to suggest, because this is the core question my Lord Narasimha asked, my Lords asked earlier. What do we do when an overwhelming set of people want to express dissent? 9/10, let's say 9 out of 10. Let's take an extreme example. How do we balance and countervail these two competing balances? The 10th schedule says you can go thus far in balancing, not further. Whereas if you are so much for free speech, courage of your conviction, this is a rotten party, I can't say, resign and contest. Recontest, what is the problem? Then the fourth is the exemptions. Apart from merger, there's the exemption clause, condonation, whatever. All that is given there. Now, what we have to see is that if a constitutional amendment balances the prohibitory with the affirmative part, you cannot find an excuse to circumvent the prohibitory part by going beyond the 4 avenues of the affirmative part, now only 3. Faction is gone. Now, Milits, let us take this further, because that's your Lordship's query. I'm sorry, Milits, there is a 5th one. I forgot. There's a 5th one. I'm now breaking it up. There is a 5th balancing on the affirmative side. You are so concerned about free speech. You are resigning is one, or you absolutely hate where you are. You go to the Election Commission and start your para 15 proceeding that I am the real party. But you do that without indulging into the prohibitory part. That's keeping the sanctity of the 10th schedule. Now I'm addressing the core dilemma of my lords. Let me develop it, in a minute. That's also a statutory remedy, lower than constitutional. So the 5th is, now actually only 4, because that faction is gone, split is gone. So 4. The 4th would be file a complaint to the Election Commission, say, look, 9 of us are standing here, we are the party, recognize us. Till then, don't do any prohibitory activity. The Election Commission will or will not recognize you and is subject to challenge. What does this do, Malis? This maintains the sanctity of the 10th schedule and maintains the negative and the affirmative parts of the 10th schedule. What does my lord normally prefer? A option I give your lordships which reduces the other option to vanishing point? Or an option which harmonizes both? Elementary principles tell your lordship by 1,000 cases that your lordship prefers the harmonization approach. Elementary common sense shows that my learned friend stand reduces the 10th schedule to vanishing point. It is as good as a dead letter or a repeal. Which is better? The answer is self-evident. Now, Milits, here, just see, Milits, how this dead letter vanishing point arises. You don't resign with the courage of your convictions to fight another election. You don't go to the Election Commission till much later. Almost a month, just under a month after 21st you went to Guwahati, 19th you go to the Election Commission. 2 days before a month is ending. You don't seek condonation. What you do is, Milits, what I call a 3 steps novel procedure to annihilate the 10th schedule. It's a 3-step novel procedure. Step 1 of which is disable the speaker by giving him a mere notice. So the man can't touch you on the 10th schedule. Just see my submission of harmonization versus vanishing point. Step 2 of this sinister 3-step novel procedure is to forward resolutions parallelly to the governor, who in turn makes it the basis of a trust vote direction. And the final step 3 is the act of being sworn in as Chief Minister.
Sorry?
The act of being sworn in as Chief Minister. With another party fully supporting, in whose lap you were in Guwahati. Now, I'm not on the... Just kindly consider. You don't follow the affirmative part, which gives you play in the joints and leeway, flexibility. You don't resign. You don't merge. The most important, interesting point is you don't merge. Just see for a minute that B, 4B. If you are sitting in their lap and they are supporting you, and the last minute, instead of them becoming Chief Minister, they make you Chief Minister, what is the problem with merging? So, you say to hell with the 10th schedule, it gives me an escape route, I'll ignore it. I'll go to the 3 steps. And the language, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. Well, this is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, well, I'm sorry to use colloquial, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the fourth one? Condonation, I'm not getting into, that's another one. Go to the Election Commission and file a complaint then. On 21st, instead of Surat and Guwahati, why did you not file the Election Commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I'm putting it against myself and trying to answer, because I put this question to myself and Lordship asked it yesterday. Now, a possible argument will be twofold. That is no argument, because how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I'm giving an answer against me, even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you? I'm putting it bluntly against myself. Well, first answer is, so what? Why was the 10th schedule created? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, but you can't, your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer? That what do? I will be disqualified. Well, jolly well you'll be disqualified, because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajanarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be there.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I'm scared of a disqualification. Now, let us look at the second. I'm giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows, Kyoto says, after final decision of the speaker, you will get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You're comparing that with what?
With the fact that, if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples. Whereas I don't know of, except a very few number of cases, where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself,
Right.
I can't assume something more than that, Again, the speaker can only reject my resignation and disqualify me. He cannot do anything more. The speaker cannot say that you shall do this or that. He'll at the most say, I reject your resignation and I disqualify you. Same remedy. That remedy, your lordship will stay in 2 seconds. Suppose your lordship had an MLA who resigned to fight a new election and the speaker, there may be bizarre cases, I don't know. Speaker said, no, I disqualify you. How long will it take a court to give a stay of that order, Malas? I mean, your lordship is dealing with these cases on and off every day, Malas, in some form or the other. But here, Malas, none of these 4 or 5 possibilities is allowed to be tried. Because you adopt a 3-step procedure to annihilate the 10th schedule. Which brings us to the harmonization principle. I'm not going to cite law, Malas, about harmonization. From ordinary petty contracts to constitutional law, your lordship's first principle is harmonization. From statutory, delegated legislation up to the constitution. Whereas I want to make the different point here that why did the 10th schedule come? Malas, we'll read Mr. Ashok Sen's speech in Malas, when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent or a third party. That's the whole long and short of this, Malas. Malas, have your lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I'm scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985, Malas? He's enacting a power of disqualification for changing a party. What is the purpose of 2/3 of parliament saying so if you can simply...
What is the harmonization principle that you're referring to?
Harmonization is this 4-fold, well, 5 originally with the faction, otherwise 4, are the flexibility, play in the joints, affirmative permissibility part of the 10th schedule. And the 2(1)(a), 2(1)(b) is the negative prohibitory part. You can do all these 4 without doing the negative part. For the negative, you don't have to violate the negative part for any of these 4. I will say even if you go to the election commission, you don't have to violate a whip. You don't have to voluntarily give up your party. You say, I'm on principle, please decide this.
So in other words, you are saying other than those 5 instances,
4 now.
Everything else falls within the net of 10 schedule.
And one more thing I'm saying, that 10 schedule, absolutely correct. And the 10 schedule has both parts. It has those 4, it has a negative. It creates a whole code by itself. Harmonization means that your lordship will adopt my submission and interpretation because it harmonizes the negative and the positive. Now for 30 seconds, see if your lordship does not adopt the harmonization principle. The only thing a lordship will have to validate is the 3-step procedure. There's nothing else, Malas. It's staring a lordship in the face. The 3-step procedure, I want to ask myself, Malas, in which case will the 10th schedule bite? Let's, Malas, be very blunt. What your lordship will do is your lordship's domain. But today, your lordship's other option, other than my option, which I am submitting most humbly and respectfully, is adopt the 3-step procedure or validate it or recognize it. But then how will 10th schedule apply? It cannot. And then, Malas, your lordships would be actually adopting an interpretation which reduces the 10th schedule to vanishing point. Actually vanishes, that's vanishing point, it vanishes. Every case of defection, I will say, I will not resign. I won't go to the EC. I won't merge. Merger is given to you by the para 4 of the 10th schedule. I will not do it. But as your lordships was told, I am the party, I am the overwhelming majority, I am the main person, I am it. I am it. Therefore, to hell with the 10th schedule. So, Malas, on principles of interpretation and much more so of constitutional interpretation than even statutory, this is a much better way to look at it than, Malas, the contrary view. Because your lordship, Malas, gives meaning to both sides and your lordship does not adopt something. What is this other adoption which is propounded to your lordships? On the high moral principle of democracy, dissent, free speech. Each of my 4 options gives you that option. So what the 10th schedule does is, it says, I am giving you a free speech option. I am giving you a democracy option, but within my own terms. I am not giving you a Jungle Raj free speech and democracy option. Otherwise, why would I enact a 10th schedule?
See, but merger, Dr. Singhvi, was not an option open to them because they were not claiming to merge their party with either the BJP or any other party.
With respect, Manoj, I'm sorry to
Right.
interrupt, Manoj. Why not?
So merger was not an option.
No, it was an option, Manoj. They did not
Of
choose
course,
to exercise
you're
it.
right, you're right.
That's correct.
It's an
They
option.
chose not to
available
exercise an option.
in the abstract, but they were not following the merger route at all because it's not their case that, look, this part of the Sena
That's
has
exactly
moved
my point.
merged with another party. That is not
That's
clear.
exactly my point with greatest
Then
humility.
the only point is that in a situation like this, where they say that we have lost faith with the leader of the party,
Yes.
then the only option according to them, according to you, is that you resign and recontest.
No, Manoj. No. I will stick to my 4 options.
That's
I'll say all the 4 options are available.
No. What do they do then?
No. Whereas resign is one.
Right.
These 9 people will merge with another political party. Why not? But the fact that I don't exercise an option
That is not an option because merger means that their political identity as the Shiv Sena is lost then.
well, then in that case, if the 10th schedule says that I recognize only this path of exit from this room, you can't say I'll make a new tunnel to get out.
But you know, Dr. Singh,
He can't
this
make a
part
new-
of your argument is a problematic argument.
problematic.
I'll tell you why. Because your argument postulates that if you have a dissension, then the only way you can express the dissension is to leave the party and merge somewhere else.
One.
They say, sorry, we don't want to leave. I mean,
Right.
ideologically, I am a Shiv Sena man. I don't want to leave, he says. He says, I don't want to leave the party.
So as per your
Kindly see, Bharat,
argument,
now kindly see the
even if,
consequences of it.
even if somebody applies to the election commission at
Yes.
the initial stage instead of in the legislative assembly.
Correct.
And says that we now want the political party to.
That we are the
accept us
political party,
as-
recognize us.
So even that, according to your argument, is impermissible then.
No. Because
So because that's outside the
so long as
5 instances that you have given,
No. One of my 5 is EC.
he's not resigned.
I beg your pardon. No. One is resignation, one is split, which is gone now, one is merger. The 4th is EC.
He's saying that.
4th is EC. Now, whereas if I apply to EC without violating a whip and get a decision, if I apply to EC without voluntarily resigning, it's perfectly permissible. I can't be saying I'll topple first and then I'll apply to EC.
So remain a member, be a part of it and
And
contemporaneously.
vindicate your principle. Absolutely. But I just see the reverse of it. But just consider how it will apply. You first topple the government, then you go to the EC. And why did you like the 10th schedule?
That we understand.
No, and also, apropos my Lord Chief Justice query, are you harmonizing or not? Whereas one more thing, the fact that you don't choose consciously not to exercise an option does not mean you can wish away the option. The option is a constitutional option. It's a constitutional option. It's as equal to split as it was earlier. You don't exercise it, it really amounts to saying this, I want to avoid the 10th schedule. So I will put blinkers and close my eyes to 4 options available. 4 constitutional options, the 5th one is deleted. And I will choose a new option, which is only the 3-step procedure. First, disable the speaker. Second, approach the governor. Third, be sworn in.
See, the negative prohibition in the 10th schedule is twofold. One, voluntarily giving up a membership, and 2, defying a whip, 21A, 21B. The 10th schedule certainly does not have any provision by virtue of which there is a prescription if you do not give voluntarily, if you do not give up the membership of the party, and yet exercise the right of working your remedies within the party.
Then you cannot be held to be a defector.
Right.
And that is the whole purpose. You were elected.
That's exactly the case, no?
No, but then in that case, why did you enact the 10th schedule? 10th schedule is not saying that Article 19(1)(a), just see 194, very interesting article. It is not saying
Crux of the
Let me put this harmonization, which is a very important principle, in another way. What is the scheme of this entire system? Well, if your lordship were to make a standard as broad as if you have a dissent, you can violate the 10th schedule, then your lordship will unmanageable.
But your
Unmanageable.
argument, Dr. Singhvi, would be
Yes.
the extreme argument on this side, which possibly you can adopt also, is that any dissension amounts to the voluntary giving up of the membership of a
No,
party.
I'm going to give more. I'm not extreme. The other argument is extreme. I'm going to give a harmonized answer. Immediately to that, the principle can never be Malas dissent. I'm not happy, therefore I can go. Three answers, Malas. One, everybody has dissent, Malas. Which political party? There are enough inbuilt outlets within the party to express dissent. One. That is what your lordship will always say. Two, the dissent within the party at the appropriate fora can be followed by any of these four. Three, you, Malas, if you are having dissensions and you are not satisfied with the party system, then Malas, you will simply express it that I am resigning or doing Malas, going away with 9/10 of the people. But Malas, how will you say that mere disagreement entitles me to topple? Here they have not expressed dissent. Malas, it's not a case of dissent. I have not gone out and spoken against the party. Dissent plus, this is dissent plus. Dissent plus toppling. Your lordship remembers I started, I think there was a Navam Revia hearing. Your lordship notices 191(2) and 194. Your lordship may not remember that, but just kindly turn to that for a minute. 191(2) is a clear statutory, constitutional prohibition in the 10th schedule saying you shall be disqualified. That's the 10th schedule comes from 191(2). Now, 194, which follows 2 clauses later, says, subject to the provisions of this constitution, there shall be freedom of speech in the legislature. And 19(1)(a) is even more reasonable restrictions. Now, it can't be that mere saying free speech, I can violate, I'll violate, you can act within the party constitution. Whatever the party constitution allows, some party constitutions have even appellate bodies, some have 2-level things. You can actually do all of it. Before you go by these 4 escape routes of merger, resignation, you can do all of it. But ultimately, if it doesn't work, you have to take these 4 routes. And 194(1) makes it clear, subject to the provision of this constitution and to the rules and standing orders regulating the procedure, there shall be freedom of speech in the legislature of every state. This is not an open-ended charter. And plus, kindly see the consequence.
Dr. Singhvi, according to you, when does the governor then order a trust vote?
No, the governor has no role at all in such a situation. Governor, first answer your lordship is when the government is formed or when the government is about to be formed. That's the inception argument. The governor will never come into a 10th schedule situation. It's what is your lordship considering? An intra-party dispute. At the end of the day, what is this dissension? I don't like you. I don't like you. Intra-party. How does it come to intra-party dispute? How does it even recognize it? There are all kinds of feuds going inside parties. How does my lord lay down in English language a judicially manageable standard to control the governor peeking into intra-party disputes? It will be the thin end of the wedge. This is nothing but political party A intra. The governor will deal with some constitutional issue or something relating beyond intra-party. And how will the governor deal without any specific article, mind you? In a sense, superseding and overdoing the 10th schedule, which is a constitutional article, with 191(2), which we tend to forget. 191(2) read with the 10th schedule. Only the
the couple of things. Step one was, as we saw, the three steps that you told us. Just
Yes,
one second, I'll just go back to it.
Correct, Manoj.
Notice of removal to the speaker,
Yes.
resolutions given to the governor, and the act of being sworn in as CM.
Correct.
There's one step earlier, probably one step which you can also add there, which was the governor's trust vote communication.
I'm grateful, Manoj. I'm grateful.
Right. Now,
Fourth step.
there,
procedure.
notice of removal of the speaker, we are not really called upon to adjudicate upon the validity of the. क्या हो गया? तो क्या है भाई? You said 3 o'clock, so they can. Oh, नहीं, अभी time है. जाओ.
No.
फिर क्या ना?
Except in Navam Rebia. Your Lordship, if your Lordship chooses to refer, would have that issue. Navam Rebia,
If we choose.
in the broad, no, I'm saying it arises. I'm not saying your Lordship may have to for this case. I'm saying that's the core issue in.
Of course,
No, I'm saying, Manoj, it's an issue. which
the governor asked for a trust vote.
Yes.
Two ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government,
Pinpointing, picking out a person and saying.
picking out a person, because
Correct.
even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. That there was no valid material at all
That's a
on the
core
basis of those three circumstances.
That's a core question. And Manoj, that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet, but perhaps didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to गलत फहमियां और भी बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं, उसने वो भी सुना जो मैंने कहा नहीं." Well, the governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 of the resolution itself there. So he's hearing things jo kaha
The
nahi.
resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had
said.
wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta, not Bashir Bhadra.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very.
No, Bombay. I'll be dealing with Bombay. That's the core question. Your Lordships is saved a lot of unnecessary exercise if your Lordship comes to that conclusion plus follows Bombay, which in any case is.
So then you, according to you, what? We reinstate the Uddhav
Just
Thackeray
straight away. Let me first change my tack and go to Bombay.
But you resign, no?
No. That's I covered in my note directly. 5 reasons. Justice Shah asked me that one in the beginning. Your Lordship asked me that. I'll straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant. Completely.
But that's Ms. Dr.
No, I'll deal with it. So let me deal with it. So let me deal with that.
If it's like the court being told that you reinstate a government which has
No, it's
an acknowledgement by you.
I hear your Lordship loud and clear.
Resign.
It's a question asked earlier, and it is actually a plausible looking thing, but it's actually irrelevant. I'll show that in a minute.
No, Mr. Kapsil, how can, just hypothetically,
yes.
How can the court reinstate a chief minister who did not even face the floor of test?
Your Lordship is not reinstating anybody.
Then what will be the consequences?
Your Lordship is and should and does, and Bommai says it more graphically, restore status quo ante. That's the meaning of a.
But Ms. Dr. Singhvi, it would have been a logical thing to do. That's where we are, it would be a logical thing to do, provided you had lost the trust vote on the floor of the assembly.
Lordship may just flag that. I mean,
because then Clearly, you have been ousted from
I-
power because of a trust vote which is set aside.
Correct, correct. Duty bound to satisfy Lordship, and I believe, my lords, that.
Right. Now, our problem is look at the intellectual conundrum.
Yes, yes.
That it's not that you have been ousted from power as a result of a trust vote which was wrongly summoned by the governor. You chose not to, for whatever reason, you didn't want to face the
Well,
trust vote.
I
and
face
that's
that
what the
squarely.
decision take.
Allow me, my lords, I'll change my sequence and come to that first right now. May I, my lords? Because straight away your lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law, your lordships. If your lordships comes to the conclusion of the other one. Give me just 5 minutes on this. May I end the first part, my lords? That is, my lords, this affirmative and negative code.
Yes, that you have made
With
a
only one, with only.
Now, Dr. Singhvi, we are 17 minutes past or 18 minutes, closing on 18 minutes past 3 p.m.
Tuesday, my lords.
I think 3:30 we'll close now. I think we have seen everything now.
No, my lords, your lordship, I'm asking, well, it's 3:30, my lords, it's now, my lords, 3:20. I've done 1 out of my 7 points. My lords, this is a matter of some moment.
But Dr.
I'm
Singhvi,
not
now
going
you
to
have
repeat-
conclude. I mean,
Well,
you can't
I'm very
just go
keen to
endless.
conclude, Malas, but it is a very useful, when your lordship asks
All
questions,
your,
interact, it's
now
very
your
useful.
points are really alaps of your.
No, Malas, with respect.
the
You are,
basic
you are
thing.
in rejoinder council.
Malas, I have argued 1 out of 8 points. I would not
All right.
otherwise take time. And Malas, your lordships, it is not
right,
intended
Dr. Singhvi,
to stop
come
your
on,
lordships, Malas, querying, because your queries are actually make us think.
All right, Dr. Singhvi, you are always very precise. You are always very
Yes,
precise. Now go on to the next point.
Your lordship's compliment is intended to render me speechless, Malas. I'm not going to be
No,
speechless.
no. No, it's not
Allow
like
me,
that.
Malas, a
Dr.
few
Singhvi,
minutes.
there is too much. The point is,
This is,
there is a lot of stuff that we have to reflect on now, and we just want you
so
to now
maybe your lordship will just
in
in a
rapid
little over
fire
4 o'clock.
summarize it for us so that we can have.
Let me speed along, and Malas, your lordship may give me a few minutes after 4 minutes. See, I am very keen to finish, Malas. I'm not, till now, Malas, I have not repeated a single point. I've given your lordship two facets.
Now not interrupt you, go ahead.
Yes. So, well, let me end this first point by saying, let me end the first point by asking myself a reverse question. What happens in my first point of affirmative and negative if your lordships were to accept their interpretation? That's a good way of answering my Malas proposition. Namely, your lordship will have nothing left in the 10th schedule. How does the lordship operate both? The 4-step or the 3-step becomes the norm and will be followed in every case to defeat the 10th schedule.
We got
That's my first point. Second point on resignation. Now, Malas, your lordship also has to deduct, Malas, till 2:20 my learned friends were occupying your lordships. And now, Malas, now the second point. Just look at this resignation trust vote a little carefully, Malas. I have 3 or 4 answers. It is irrelevant for the following reasons. Well, it's just turn to
Dr.
para
Singhvi, the
14.
reason why we are wrapping you up, so to speak, is not because you have no case. We are
No, Malas.
to ask you to wrap up only because now the burden shifts
now
heavy on us
thinking
to, as
the burden.
adjudicators, to apply our mind and
Yes.
step back
No,
and
so let me, Malas, now
decide.
speed up. I think, Malas, oral things help, but to speed up, let me ask you lordship to read para 14 of my note, A7. Para 14.
Just formulate it for us.
Yes, the formulation.
We've now got a.
When, Malas, now I'm answering
para
the second
14,
head.
no? ठीक है, page 7.
I had 6, 7 heads. This is my second head.
Education.
And it starts, Malas, this head starts at page 6. It starts at para 9, page 6. Resignation.
The act of resignation.
The act of resignation subsequently on 29 June would not defeat and would have no relevance to the reversal of the illegal action of the governor of 28/6. And in accordance with precedent, this honorable court should effectuate a real and meaningful remedy. Now, Malas, your lordship recollects my A3 submissions, para A to N, which are repeated here. I argued, Malas, ibi jus, ibi remedium, fait accompli, status quo ante, all that. I'm finishing off in one para. I'm not arguing. I'm just reminding your lordships. Now, skip all that and come to, Malas, para 14 for a minute. Does my lord have para 14? Once the illegal act of the governor is allowed to be implemented, the result was a known and foregone conclusion. Factually, there was no need for the ex-CM to subject himself to it. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote.
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act,
Yeah.
the consequence of that is known to me. Now, just to save time, let me read it. The crux of the issue raised in the petition, where Lordship has got 14A malus, 14A third line. The crux of the issue raised by the petitioner remains that the direction to hold the trust vote was an illegal act because the governor did so by recognizing a faction of 34 legislators. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, so prior is important, and pending in a court, a participation or absence of participation of ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, if one, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote, it would make no difference in law because the trust vote was merely the consequence of the illegal act of the governor. And the challenge would still relate to the governor's actions and not to the trust vote. D, it is therefore obvious in law that the consequence of an illegal act, emphasis on consequence, cannot determine the legality of that act or validate it. Indeed, it could also be said that the petitioners, having challenged the core illegality at the base, namely the governor's actions, without any delay, did not even need to challenge the trust vote. I could have said it's nothing but a consequence. Similarly, if the individual illegal actions are broken up, and there are different petitions, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor inviting and administering oath, the participation or absence of the ex-CM has no relevance. Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para Malas.
So this is the second point. No, Dr.
This is the
Singh?
second point, but just one thing is left here, Malas. Para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law EBUs, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, Malas. In that, kindly, Malas, do me the favor of treating it as having stated here. Now, Malas, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Karnataka and Meghalaya, is very important, is liable to be struck down and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have happened in the intervening period. Now, just this is very important. This has not been shown to your lordship. Just give me a minute. 398 and others, 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 356 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the lordship holds the governor to be bad, then a person not entitled to be holding the post of chief minister. How can, of all courts, the Supreme Court accept such illegality? If your lordship's powers are unique in this country, in that even your lordship's can go beyond the law. Not contrary to law, beyond the law. Then, what's the point if the governor's actions are held to be illegal? Actually, your lordships would be giving a Parikh declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now, let's just see next one. In state of Meghalaya, it's very interesting. For the other state in Bomai, para 12 of my note. Again, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored in Meghalaya. We would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted and all, no relief is granted consequent upon the declaration. Therefore, Malas, this is the heart of this point. Now come to Malas, page 1 on 189. The third point is 189. All right. That is coming separately. That's coming separately.
What is the point, Dr. Singhvi?
Yes. Now, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued, I
Page
believe.
189, I'm sorry to interrupt. What is 189? Dear?
No, page 1.
Page 1 of my note. That is, the de facto doctrine that actions validated by the actual act, which is challenged, is illegal. I want to show how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. The first important thing is to note that there are two kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your Lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. Learned friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
It is said in the context of the vote in the House.
So,
with respect to
exactly. So, therefore, no. 189, your lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra
you're
government
really
made
saying
a liquor policy,
Dr.
therefore
Singhvi,
that
what
is
you're
gone.
saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid.
Correct.
But that does not validate the original appointment
That's
itself.
that's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for that goes back to the same thing, First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot.
What you're saying is that if the calling of the voting in the House itself is subject to
just how my lords formulated was right or wrong. Governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
But that's the affirmation of the House, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bommai dealt with the affirmation.
All right.
Bommai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, will be quashed. Can you come to that now? So first, let's come to, yes, I'll just show 50. Just keep 356. Maxima's query answered by Bommai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there's nothing. There was a presidential proclamation affirmed by Parliament in Bommai. Now come to para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected. In Bommai, does my lord have it? Para 4. Do my lords have it?
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court, held a clear majority, 5 judges, that if a proclamation on 350 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 189, this is express approval. This is express approval. Now read this para, very interesting. 110, Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bommai has a...
Now there is one interesting, very interesting, after 29 years and 2 days, This is happening in your Lordship's court. This para 110, that bold-face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No. We've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then the SCC
Dr.
issued a
Singhvi,
corrigendum.
I must also publicly acknowledge there was a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that we are all
It's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus or anything. It's just a love for the job that they do it.
The time, money.
Private sector is clear education.
Your Lordship is entitled to judicial
Ah.
right.
Batao. You are part of them.
Was.
No, this is just an aside. The
I was
word
saying private sector or senior councils, I said. Chief is saying.
some of your lordships, most of your lordships.
I told my learned brother, you are
Stop.
part of them too.
Complete estoppel.
Estoppel, that's why I didn't.
And a very recent estoppel, relatively. Now, the word invalid here is by corrigendum, the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the President if the proclamation is invalid, yet it is approved by both houses? Come to 111 Lordship. See, I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. The action will undoubtedly be illegal. Then we'll skip 10 lines. There is no reason why the Council of Ministers and the Legislative Assembly should not stand restored as a consequence of the invalidation of the proclamation, the same being the normal legal effect of the invalid action. In the context of constitutional provision which we have discussed, and in view of the power of judicial review vested in the court, such a consequence is also a necessary constitutional fallout. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible, it's permissible to have a complete restitution, is what you say.
Otherwise, it's meaningless and nugatory. The 9 judges say that, and next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry as well as the Legislative Assembly. Then para 114, boldface. Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary consequence of the invalidation could be to restore the status quo ante. Therefore, to restore the Council of Ministers and the Legislative Assembly as they stood on the issuance of the proclamation. So, if your Lordship is otherwise convinced, your Lordship needs no support than more than a 9-judge bench, which is very clear. It may, however, to be made clear. Next sentence is very important. Next boldface. It is, however, to be made clear that the interlocutory relief that may be granted on such challenge to prevent frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its function. And then to conclude, the court in appropriate cases not will be justified in preventing holding of fresh elections, but will be duty bound to do so by granting suitable interim relief. Then, they summarize the conclusions, which I will not read to save time. Clearly, para after para is devoted by Justice Sawant and Justice Kuldeep Singh. And just see 7, another phrase, molding of relief, big Roman 7. Otherwise, what's the point your Lordship is exerting so much, if your Lordship comes to that conclusion with great respect? And that to a court with 141, 142 and special powers. I can understand the High Court possibly flinching. According to me, even the High Court has the power to do it under your Lordship's judgment. Now, Justice Jeevan Reddy said this, even in case the proclamation is approved, it would be open to the court to restore the state government to its power. If this were not conceded, look at these words, 9 judges, 29 years ago. If this were not the case, the very power of judicial review rendered nugatory, entire exercise meaningless. The court cannot grant the relief flowing from the invalidation. It may well decline to entertain. Well, they say if you can't grant the relief, why did you entertain? That's what this court is saying, 9 judges. And then Justice Pandian, just 2 lines above 4A. I find myself in agreement with the opinion of Justice P.B. Sawant on conclusions 1, 2, 4 to 8. This includes my conclusions, which I have just read, 4 to 8. So this is, the 3 points are covered: prohibitory, affirmative, 189, and resignation. Now, the 4th point is this prospective and retrospective of the EC. They're all important queries which fell from my Lord. My Lord the Chief Justice asked this question more than once.
That is C.
That is my C, my Lord is right, pages 8 to 10.
Page 8.
Just forget everything else. I'll take one point here is enough. Whatever else your Lordship holds, on the bare text, textually and facially, symbol order number 15 has to be prospective. Forget all we'll come to the interpretation. Just read the text facially. That's at para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. As drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the Commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the Commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the Commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. Well, this cannot but be futuro. Number 2, look at the consequences of holding otherwise. There will be very, very strange consequences. 2 things, fellows. If your Lordship were to hold the 19th July, that's the date, order of the EC. 17th February 23. I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, fellows, the order to be retroactive, question number 1, retroactive from when? There are 3 possibility retrospectivities. Look at the consequence. The Lordship doesn't hold it to be without the consequence. 3. One is, it is retroactive from the date the Shiva Sena was recognized as a 29A political party. That was 1990 or 92. I'm giving you 3 alternatives. I'm not... because today I am the Election Commission, I hold that this is the Shiva Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only 3 possibilities, Malus. In all of these, the consequences would be that, Malus, actually everything, I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available. And people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification if your Lordship relates back that. So your Lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your Lordships will not avoid the inevitable consequence by, of course, your Lordship's words can always, but that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. And therefore, I am liable to something, or from actually, logically speaking, from the origin. Therefore, this... Huh? And it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. Would also go without there being a fresh election unseating him. Everything will go, No adjudication. By the mere act of recognition relating back either to 1990s or to 19th of July or to 23, 21st of June, there would be chaos. The consequences are, and apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next point, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a Lordship of Rajendra Rana. Note this well, note this. Not a single judgment even of any high court, leave aside Supreme Court, says that the election commission will relate back. A constitution bench has held the field for very long, saying a disqualification 10th schedule order relates back. If your lordship were today to do this, your lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a constitution bench to relate back. And your lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, Malas, suppose tomorrow the speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to Malas, June 22. But there cannot be disqualification because by then your lordship also would be applying a EC order retroactively. Therefore, Malas, your lordship already has jurisprudence and a precedent.
Prospective, according to you. All right.
Then, Malas, the fifth aspect is this political party and legislative party.
Dr. Singh, we now 5 minutes now.
Malas, we will finish before lordship's time. He will, within this time, we'll finish. We are conscious of that. Malas. 3:45 minutes, we'll finish within time. I'll give him 5 minutes also. He'll have 5 minutes. Now, Malas, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibbal's. This is very well different. Kindly, Malas, read this from a different perspective.
F, right?
Yes, F. Starting para 35, page 12. Well, as members of a legislature party do not have any right to act contrary to the directions of their political party. This is the heart of the political party, legislative party debate, with which Mr. Kaul also started today at 2 o'clock. As per 194(1), the freedom of speech is subject to the provisions. I pointed it out already. Under 170(1), the assembly of a state consists of members. The members are elected by direct election from territorial constituencies, and the nature of the election process is such that an elected member set up by a political party has no independent identity in the House except as a member of the political party. Well, actually, in practice, how we sit, where we sit, which rooms we are given, is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first-time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10th schedule, prior to 85, the constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. Even though political parties were always recognized to be an essential component of the Westminster form of parliamentary government, political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the 2 statutory levels. It came in Malas for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, our lordship is being asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party, by its very nature, is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And Malas, your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislative party is used. First, in 2(1) it says, a member of a house belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition? Then, Malas, there is no mention of legislature party in para 2. None. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislature party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the fraction of 1/3 goes Malas. In para 4(2), it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it's described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. If no defense is claimed, the legislature party has no constitutional or legal relevance, is para 43. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument, dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say and that's too broad a basis for your lordships to act or give any judgment on one. Dissent. I just say I'm dissenting and I leave the 10th schedule. Reliance is placed on the law of speaker, where deho the legislative assembly, disqualification rule, the president of the political party who was not a member was given the right to maintain disqualification. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Quixote. That para has been read one sentence, but read the whole of it. This is directly the point raised in Quixote. Your lordship should not be referring, Nawab Your lordship be reconsidering Quixote also on this basis. Now kindly see. This is a very important para. Para 49 at PDF page 109. 109. Very telling para, directly the same sentiment. How do you harmonize the two? And you cannot allow one to be reduced to vanishing point. Kindly see this. And I'll end in about a minute or 2 minutes. Indeed, in a sense, may I read this, fellows? 109. This is very, very important. It's a covered field. Your lordship need not be agonized about it, as my learned friend would like your lordships to raise a new issue before. It's a covered point.
1090.
109 PDF, CJ2. CJ1. CJ1. Inappropriate acronym, Malas. We used to call it CL1, Malas. Case law 1. I don't know where this time. First time I found CJ1, Malas. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better, Malas. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially with the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. Theoretical assumption. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution, and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances, you don't follow them, but you follow this. This is what is extremely unfair. This is what is actually, this is again like that technique of giving a notice to the speaker. It is trying to decimate what is the entire 10th schedule by saying dissent. Dissent has to be within the boundaries of that. But I'm extremely grateful and
Thank you, Doctor.
very deeply obliged.
Thank you, Doctor. Yes, Mr. Comment.
Lords, so I'll finish in 5 minutes, my lord. The 5 minutes left. Lords, I have put my thoughts in rejoinder in additional rejoinder A5, my lord, which is just a 5-6 page document. I have just 5 submissions to make. The Lordships kindly have that. My Lords, I had addressed your Lordships on writ petition 479 of 2022, which was a challenge to the decision. Lord, that is A5. I'm sorry, my lord.
Right.
It's rejoinder, additional rejoinder A5, filed yesterday.
Yes.
Yes, ma'am. My lords, I had made submissions, my lord, only on writ petition 479, which is challenging the validity of the decision of the speaker on 3rd of July 2022. That is, my lord, the change of recognition from Sunil Prabhu to Bharat Gogavle late in the evening of 3rd July. Now, my lords, the validity of this decision is, my lords, unconnected with the ultimate, my lords, view which your lordships will take in the disqualification proceedings, whether your lordships want to decide it here or send it back. This, my lords, challenge is an independent challenge. Your lordships will have to determine whether the speaker was right or wrong. And the only defense which was taken originally in the reply was that it is 212. It is inside the house. And I had said that that is completely in the realm of unconstitutionality. There has been absolutely no rebuttal, my lord. That I have indicated in paragraph number 2, my lords, item 2. 3, my lords, I had submitted sub-Roman small 3, that the term political party is not an indeterminate, nebulous concept. Today, there are 30 people claiming, there may be more factions claiming that I am the political party. But on 21st of June, there was only one political party that was, my lord, in writing, which was communicated to the Election Commission, that was headed by us. Not with respect. This is not, my lord, a Narova Kunjarova. My lordships are aware of Mahabharat, my lord, that Ashwatthamo Hata, Narova Kunjarova. Whether they are Shiv Sena, we are Shiv Sena. In June, my lord, still they filed a petition on 19th of July. There was no dispute. There can't be any dispute in law that I represented the political party. So that's the second point which has not been answered as far as section 29A is concerned, my lord. Now, my lords, Mr. Sibal has pointed out about the validity of the whip, my lord, and that only the political party can issue a whip, and that Erskine and May, all that was cited. And my learned friends have argued that no, it's the legislature party can issue the whip, Rule 3.1, etc. The lordships have seen Rule 3.1. Rule 3.1 does not deal with a whip. Neither the form deals with a whip. That is by convention, and in fact affirmed by your lordship's judgment in Mayawati. Kindly have the highlighted portion, my lord. Paragraph 73 of Mayawati, reproduced in paragraph 3 here. Whatever direction is issued by the leader of such legislature party must be regarded as a direction issued by the political party. This was the argument. There is no merit in this contention when the provision in the Constitution has taken care to make a distinction between the legislature party and the original political party and prescribe that the direction issued should be one issued by the political party or by any person or authority authorized in this behalf. There is no meaning in saying that whatever the leader of the legislature party directs must be regarded as that of the original political party. This is Mr. Kaul's argument, my lord, specifically rejected. Now, my lord, all this parliamentary convention which we have set out in paragraph 4, my lord, has not been rebutted. Not even one precedent shown, my lord. Now, my lords, kindly turn to Roman 3. And this is a legal submission, my lord, that having a legislative majority ipso facto or ipso jure is not suggestive of a majority in the political party. My lords, Roman 1 and 2 have already been dealt with. Now, my lords, kindly have Roman 3. In fact, my lord, there are one-member legislature parties. And in those, my lord, circumstances and facts, Election Commission has said that we have to see the organizational majority to see who's the political party. So therefore, my lords, merely saying that you are a legislative majority and therefore you represent the political party is legally incorrect. Now, my lords, reference was made to Sadiq Ali, that Sadiq Ali, my lords, affirms this proposition. In fact, in Sadiq Ali, my lord, this point was kept open, and I have highlighted that, my lord. Kindly have a look at Roman 4, the highlighted portion. The present is not a case where a conflict has arisen because of one group having majority in the organizational wing and the other having a majority in the legislative wing. This is fallen for consideration here. Now, my lords, one submission was made by Mr. Jethmalani yesterday that, look here, we are also members of the Pratinidhi Sabha. Therefore, we represent the political party. Lords, on affidavits in the Election Commission and also here, for which there is no rebuttal, out of 220 Pratinidhi Sabha members, 160 plus, my lord, have supported me. 160 plus, not rebutted. Now, my lords, kindly see the next submission which is made. And this is again Mr. Jethmalani's submission, that Quixote said in paragraph 97 that the decision of the speaker is not covered by 212 and that the rules made under paragraph 8 have a constitutional status and therefore violation of that 2-day period or 7-day period is violation of the constitutional mandate. Totally against Ravi Nayak, my lord. Not even one judgment was cited in support of that submission, but kindly see Ravi Nayak, it's covered. Now kindly see paragraph 8, my lord, the highlighted portion. The disqualification rules are procedural in nature and any violation of the same would amount to an irregularity in procedure which is immune from judicial scrutiny. Then, my lords, I just have 30 seconds, my lord, I'll just finish now. My lords, then a reference was made to some speeches, my lord, that I have dealt with. Lord, some speech of some DG is totally inadmissible. My lordships have held it time and again, which your lordships have seen in Kalpana Mehta Constitution Bench and also in Shivraj. Speeches by, my lords, members, totally irrelevant, my lord, to decide what the scope of the provision is. Yes, my lord. Then, my lord, para 6, they said that mere non-attendance of a meeting will not amount to a para 21A. Specifically, my lord, this was the issue in Shriman Balasaheb Patil. One meeting they didn't attend, it was held to be a para 21A, which I have reproduced, my lords, in paragraph 14. Now, the last thing is important. Kindly have paragraph 15. My lords, time and again, my learned friends, my lord, said that we have never claimed a split. In fact, I remember, my lord, Honorable Justice Kohli asking Mr. Kaul, is it your case that there is a split? And he said, on more than, my lords, 5 occasions, which I have reproduced, kindly see this. First, our case is not a split at all. I have never argued I have a split. Now, kindly see the submissions before the Election Commission. And now the cat is out of the bag. Please have a look at paragraph 16, my lord, of my note. And I've reproduced paragraph 7 of their petition before the Election Commission. In view of the above mentioned facts and circumstances, it is evident that there is a split in the Shiv Sena. And all the written submissions filed by Mr. Mahesh Jethmalani and Mr. Shinde, my lords, categorically say there is a split. I have pointed that out, my lords, in paragraph 17. To come here, my lords, and say that we are a faction, we represent the political party, is only sugarcoating, my lord, the factum of a split. Lords, lastly, my lord, ultimately your lordships will decide. Lords, I am reminded of my lord's Sanskrit Subhashit, my lord. And it says, my lord, Kakaha Krishnaha, Pikaha Krishnaha. That, my lord, the crow is also black, the cuckoo is also black. Ko Bedaha Pika Kakoy. What is the difference? Who's the Shiv Sena here? Vasanta Samaye Prapte, Kakaha Pikaha Pikaha. And I'm sure, my lords, the time of judgment will be clear, my lord, who's the real Shiv Sena. Thank you so much.
We'll be failing in our duty if I don't mention that the assisting counsels, my lords, on both the sides did a phenomenal job in assisting us. And very grateful to your lords for all the time.
Our compliments to you for
Yes.
Rohit Sharma, my lord,
Yes, my lord. Rohit Sharma is, yes.
Invaluable assistance. my lord.
our compliments
All on the sides, my lords, they did a phenomenal job. We could not have argued this without their
to
assistance.
the juniors is also
Yes.
to us.
We are
Very grateful, my
very
lords, for all
patient
the
hearing.
time that your lords gave us, for all the time that your lords.
We'll
Grateful,
reserve judgment.
grateful.
Very, very grateful.